Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
Oh.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you. Good for California.
It used to be that shopping for a gift meant taking a trip to Main Street. Boy, how things have changed. These days, you don't have to leave the comfort of your own home, thanks to the convenience of online shopping. But there's something you should know about shopping online. You may owe use tax. When you buy a gift online, look to see if you were charged tax when you checked out. If you weren't, then you may owe use tax. It's similar to the sales tax you pay when making purchases from stores in California. Use tax is typically owed when you buy from an out-of-state or online seller that does not charge you tax. It's easy to pay your use tax. Just report and pay it on your state income tax return, or download and use our BOE mobile app. The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. We hope your next birthday, anniversary, or holiday gathering is filled with many great memories.
Come on, Grandpa!
And lots of great gifts.
You brought a couple gifts.
Bring them in, boys.
But don't forget to keep track of what you buy online, because you may owe use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you. Good for California.
The Taxpayers' Rights Advocate of the State Board of Equalization wants you to know you have rights. As a California taxpayer, your rights are protected during the assessment and collection of taxes, including the right to courteous and prompt service and the right to be treated fairly during all dealings with Board of Equalization employees and officers of the Board. Publication 70, Understanding Your Rights as a California Taxpayer, and Publication 145, California Taxpayer Advocates, can be useful in learning about your rights. If you feel the BOE has not resolved your concerns adequately, please contact the Taxpayers' Rights Advocates Office at 1-888-324-2798 or email us. The Taxpayers' Rights Advocate of the State Board of Equalization. We're here for you.
It's easy to buy things online these days, but did you know you may need to pay tax on those items?
Really?
It's called use tax. And just like sales tax, the use tax you pay to California will help fund important services like public safety, healthcare, and schools. But how do you know if you owe use tax? When you buy things online, look to see if you were charged tax when you checked out. If you weren't, you may owe use tax. It's easy to figure out how little you may owe. For most purchases, you don't even have to save your receipts. Just use this convenient use tax table, available in your income tax instructions. Find your adjusted gross income to see how much you may owe, and enter that amount when preparing your state income taxes. It's that simple. No looking through files and no hassles. You've paid your use tax for the whole year.
That was easy.
Paying your use tax. Good for you. Good for California.
We're committed to supporting our communities, teaming up with businesses large and small, improving our roads and schools, investing in law enforcement and our environment. Together, we're funding a better quality of life. We're the California State Board of Equalization. The BOE was created in 1879 to equalize property tax assessment practices throughout California. Our responsibility has grown quite a bit since then. Today, the BOE administers more than 30 taxes and fees that provide 1/3 of all the revenue generated in our great state. And we're efficient. More than 99% of the money you contribute supports services and programs that benefit all of us in California. When you drive down our many highways, see a police officer helping someone in need, or enjoy a walk along a pristine beach, think about what makes it possible. Whether you're a business owner, making a purchase, or just filling up your gas tank, your contributions are important to our state's economic health. And the greatest part, we're doing it together. We're ready to work with you. Take advantage of our free seminars, helpful classes, instructional videos, and mobile applications. Also, use our online services. It's easy to do business with us from anywhere, at any time. Our partnership equals success. Learn more at boe.ca.gov. Together, we're supporting our communities and funding a better quality of life.
Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you. Good for California.
Good morning, members and guests. Ms. Richmond, will you please call the roll to establish a quorum?
Good morning, members. Chairwoman Ma,
Here.
Ms. Harkey,
Here.
Mr. Runner,
Here.
Mr. Horton,
Here.
Ms. Stowers.
Here. There is a quorum. The Board of Equalization is hereby called to order. We will commence with the Pledge of Allegiance led by Staff Sergeant Rigo Nieves. Staff Sergeant Nieves came to the Board of Equalization in July 2014 as a business taxes representative in the Culver City District Office. He has been with the Air Force Reserve since 2009. He is currently a Staff Sergeant with the 50th Aerial Port Squadron. Someone going to find him? He deployed to Bagram, Afghanistan in 2011 to 2012 with the Aerial Port Squadron out of the Travis Air Force Base. He will be deploying to the Middle East in January 2018. Was he here earlier? Was he here earlier? Oh, you haven't seen him. He'll be gone for a while. So let's see if we can find him since he's deploying again in January. Oh, 2018. Oh,
Got a while.
he has a while. Okay. Maybe he can do the pledge next time. Okay. How about Mr. CHP? What is your name? Officer Dominguez. Officer Dominguez, would you like to lead us in the pledge? Of course. Thank you. Okay.
Alrighty. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Thank you, Officer. Okay, Ms. Richmond, please call the first item. There's a couple of changes to the agenda. Maybe we can announce those changes. First, 2 taxpayers are not going to be here today, and one is on its way, right? The representative's on its way.
Correct. So our first case, B1 Caesar Z. Lugo. We are postponing that case. The taxpayer is ill this morning. Item B3 has been postponed. And item B2, the representative is stuck in traffic, so we'll be hearing that case when they show up.
Okay,
So our
so the
first
first one.
case this morning will be item B4, James K. Brewster. Please come forward. Board Proceedings has received contribution disclosure forms for today's hearings from the parties, participants, and agents. All forms were properly completed and signed, and no disqualifying contributions were disclosed. All parties, participants, and agents are on alpha listings provided to your office. Each person sitting at the table will be asked to introduce themselves and, if necessary, their affiliation with the taxpayer for the record. 10 minutes is allocated for the taxpayer's opening presentation, followed by 10 minutes for the franchise tax board's or the department's presentation, and 5 minutes is allocated to the taxpayer for rebuttal. Ms. Ma?
Okay, thank you. Mr. Eppolite, would you please introduce the issues in this case?
Good morning, Chairwoman Ma, members. The issue before the board in this appeal is whether appellant is entitled to the head of household filing status for the 2013 tax year.
Okay, very good. To the appellant, welcome to the Board of Equalization. You have 10 minutes to make your initial presentation, and then you will have an additional 5 minutes on rebuttal. Please introduce yourself for the record, and then you may begin your presentation.
Thank you, Madam Chairwoman, members of the board. My name is Kat Castro, and I'm appearing on behalf of the appellant, Mr. James K. Brewster. Unfortunately, he'll be unable to make it this morning, but I would not like to postpone the case.
Okay, please begin.
Although the issue has been phrased as whether appellant is entitled to the head of household filing status for the 2013 tax year, I would like to submit that appellant has already conceded that, as the law is currently written, he does not meet the legal requirements that would entitle him to use such a status, and this concession is reflected on page 1 of Exhibit D, and also mentioned in appellant's supplemental brief. Instead, it's appellant's position that the issue before your board this morning is whether the state should be stopped from its denial of the appellant's use of the head of household filing status for 2013, when 1, Mr. Brewster's use of such status was pursuant to government instruction as featured in the 2012 written stipulation for judgment that finalized his divorce, and 2, when he detrimentally relied on the court order's instructions as the basis of his use for the head of household status. Would the board care for a brief recitation of the facts?
Yes, please.
Prior to 2012, appellant had been married for 15 years and had 2 daughters, Nicole and Kayla Brewster. After a decade and a half of marriage, appellant and his ex-wife filed for divorce. In open court during the divorce proceedings, Mr. Brewster was instructed by the judge to use the head of household filing status and to claim his 2 daughters as dependents. In addition, his ex-wife was ordered to use the single filing status. Appellant later timely filed a California income tax return for the 2013 tax year, claiming first the head of household filing status and second the 2 dependent exemption credits for his daughters. With his 2013 tax return, appellant completed a 2013 head of household audit questionnaire in which he stated that his daughter Nicole qualified him for the head of household filing status. However, based on the information received in the head of household questionnaire, respondent issued an NPA on October 1st, 2014. In this NPA, Mr. Brewster's claim to use the head of household filing status was denied because his home was not the main home for Nicole for more than half of the year. The NPA also disallowed one of the dependent exemptions credits because, based on the information provided by Mr. Brewster, his daughter didn't qualify to be his dependent. The NPA then revised appellant's filing status to single and it proposed the additional tax of $1,795 plus the applicable interest. Since then, Mr. Brewster has protested the NPA and appealed the subsequent notice of action, which has led to this hearing before your board today. To begin with my argument, the equitable estoppel is a doctrine built upon a foundation of conscience and fair dealing. The Supreme Court described the doctrine as, quote, "He who by his language or conduct leads another to do what he would not have otherwise done shall not subject such person to such loss or injury by disappointing the expectations upon which he acted." California courts have held that equitable estoppel can be alleged against the government in cases where justice and right require it. Therefore, in select circumstances, a taxpayer may assert the doctrine of equitable estoppel against the state of California if the taxpayer relied on the actions of the state to his or her detriment. The equitable estoppel inquiry features 2 points of analysis. First, each of the 4 elements of equitable estoppel must be met. These elements are: 1. The party to be estopped must be advised of the facts. Second, that party must intend that its conduct be acted upon by the taxpayer, or it must act in such a way that the party claiming estoppel, in this case the taxpayer, had a right to believe it was so intended. Third, the taxpayer must be ignorant of the true facts. And finally, the party claiming estoppel, in this case again the taxpayer, must show detrimental reliance. So, we begin our inquiry with the first 4 elements of equitable estoppel. First, the party to be estopped, the state of California must be apprised of the facts. Respondent claims that due to insufficient information, respondent did not have a clear picture of all the facts and circumstances in the matter. However, respondent does not attempt to support its statement without any evidence. It is appellant's position that respondent was in fact provided with a clear picture of all the facts and circumstances in the matter. This assertion is supported by respondent's own admission of its awareness of the existence of the judgment of dissolution that ordered that appellant use the head of household filing status. In its opening brief, respondent admits that when an appellant faxed his protest of the notice of proposed assessment on December 5, 2014, appellant provided a copy of page 5 of the judgment of dissolution titled Child Support as evidence of his assertion that the court ordered the appellant use the head of household filing status. In addition, appellant attached a complete copy of the judgment of dissolution as Exhibit A of his reply brief. The first element is therefore satisfied because, first, respondent was fully aware that as reflected on page 5 of the judgment of dissolution, appellant was ordered by the court to use the head of household filing status. And second, respondent issued its additional assessment despite its awareness of the judgment of dissolution's instructions. The second element is the state who is the party to be estopped must intend that its conduct shall be relied upon. It is clear that respondent intends that the taxpayer shall act upon its conduct, which is manifest in its notice of action dated August 12, 2015. Respondent's conduct in its disallowance of appellant's use of the head of household filing status, in spite of the judgment of dissolution ordering appellant's use of this status, because appellant does not meet the statutory requirement that his qualifying daughter live with him for 183 or more than half of the year. Respondent intends for appellant to act upon its conduct by requiring that appellant either 1. File under a filing status other than the head of household in violation of the judgment of dissolution, or secondly, provide respondent with evidence of appellant's eligibility to use the head of household filing status, which, according to the statute, he does not meet. And he has also conceded to this fact. Third, our party, the taxpayer, must be ignorant of the true state of facts. In the present case, the relevant true state of facts is respondent will not allow a taxpayer to use the head of household filing status even if a court order instructs the taxpayer to do so. If the taxpayer does not meet the eligibility requirements of the head of household status, respondent contests that it cannot be said that appellant was ignorant of the true state of facts. At the time that appellant filed his 2013 tax return, he was in a position to know the true state of facts in the matter. Respondent further claims that appellant must bear the responsibility in determining the correctness of his tax filing and tax liabilities. Appellant did bear the responsibility of determining the correctness of his tax filing status and tax liabilities because he appropriately obeyed the judgment of dissolution's order to use this head of household filing status. To appellant, the true state of facts was, although appellant might not have met the statutory requirements to be eligible for the head of household filing status, because appellant was ordered by a branch of government to use this status in order to comply with the judgment of dissolution, appellant was exempt from the normal statutory eligibility requirements for the use of such status. Finally, our party must have relied upon this conduct to his injury. Appellant detrimentally relied on this judgment of dissolution to file the head of household filing status. Respondent notes that in order for detrimental reliance to be present, respondent's actions must cause the taxpayer to tax action that leads to increased tax liability. Respondent then argues that detrimental reliance is not present in the instant case because appellant did not offer evidence demonstrating that the advice he received caused him to take action which led to an increased tax liability. Appellant disagrees. Page 1 of the FTB publication 1540, titled Tax Information for Head of Household Filing Status, Tax Year 2013, features the bolded heading, Benefits of Head of Household Filing Status. Under this heading, it reads, the head of household filing status provides two benefits if you qualify. First, a lower tax rate, and second, a higher standard deduction than either the single or married RDP filing separately filing status. One may reasonably infer that the emphasized language above indicates that should a taxpayer be unable to qualify for and use the head of household filing status, the taxpayer will not receive the benefit of a lower tax rate. Thus, given respondent's own definition of the benefits conferred upon the taxpayer for use of the head of household filing status, because Mr. Brewster was unable to use this status, he is at a detriment. In addition, notwithstanding the injury produced by the additional tax liability, Mr. Brewster's detrimental reliance on the judgment of dissolution's instructions to use this status produces another, more concerning injury, a violation of a court order which would place appellant in contempt of court. Respondent asserts that because appellant cannot show that he explicitly advised to file his tax return using the head of household filing status for the 2013 tax year, and that he relied on such advice to his detriment, it's respondent's position that appellant clearly cannot apply the doctrine of equitable estoppel in this matter. Furthermore, respondent incorrectly speculates that since the stipulation was signed in August of 2012 and the dissolution was final on August 29th of 2012, Any suggestion by the court that appellant use this status may have been meant for the 2012 tax year for filing in 2013, not necessarily meant for the 2013 tax year, which is at issue here. Appellant disagrees with both of these assertions because appellant has shown that he was explicitly advised to file his tax return using this status, which is reflected on Exhibit M, page 16 of 16, featuring the Judge Patty Radican's signature.
Time's expired.
Okay. Thank you, Ms. Castro. You'll have 5 minutes on rebuttal to the Franchise Tax Board. Please introduce yourself for the record and begin your presentation.
Good morning, Chairwoman Ma and members of the board. My name is Brad Catino. Sitting to my right is Marguerite Monnier, and together we represent Respondent Franchise Tax Board. As stated in your board's hearing summary, and as appellant has conceded today, appellant is not eligible for the head of household filing status. Because that is the only issue on appeal, respondent respectfully requests that this board sustain respondent's action. Concerning appellant's argument regarding equitable estoppel, respondent believes that doctrine does not apply because respondent did not misrepresent the law, nor did it make false promises. Equitable estoppel is applied in rare and unusual circumstances when its application is necessary to prevent manifest injustice. A taxpayer must prove for equitable estoppel that respondent made affirmative misconduct beyond negligence and amounting to either ongoing active misrepresentations or a pervasive pattern of false promises. Appellant alleges that respondent should be equitably estopped from denying him head of household filing status because he detrimentally relied on a valid court order. However, there is no statute or case law that requires respondent to follow an agreement in which it was not a party to. Further, appellant has not alleged, nor is there any evidence, that respondent made active misrepresentations or false promises to appellant. Accordingly, there are no grounds to apply equitable estoppel in this case, and respondent requests that its action be sustained. I'd be happy to address any questions or concerns the board may have at this time.
Okay.
Thank you for your time.
Thank you. Ms. Castro, 5 minutes on rebuttal.
First, I'd like to clarify that we are alleging that the doctrine of equitable estoppel should be applied against the state of California as a whole because in this case we have two entities that are clearly in conflict with one another. It appears as though what respondent is saying is that in order to remedy this situation, Mr. Brewster would have to go back into court on his own time and dime to request that the judge either vacate the written stipulation for judgment or be in contempt with the FTB. He's kind of in a catch-22 situation here. And on Exhibit M, page 5 of 16, it shows that under the tax filing status, it indicates HH-3 for Mr. Brewster and S1 for his ex-wife, which indicates that the judge, which was signed on page 16 of 16, that the judge stipulated to this. So he's either in contempt of court or he is disobeying the Franchise Tax Board. And it's these considerations of justice and right that the doctrine of equitable estoppel is rightly applied. Any questions?
Okay, thank you. Ms. Richmond, can you give her some water? Okay, members, questions? Mr. Renner.
Yeah, let me,
Oh, you have water. She has water. Never mind.
the document that you're referring to, I'm trying to determine in my own head whether or not this is like, indeed part of the agreement that the court had made, or whether or not it was just incorrectly identified in terms of the roles.
Mr. Brewster has indicated, and I also distributed Exhibit N, which is a signed declaration because he couldn't be here today. But this was discussed in open court and then reflected in this. But basically, to Mr. Brewster, if a judge signs off on this and this is now a court order, he's supposed to obey it. So which entity does he disobey?
What difference would it make in his filing status to the order? The order is about payment of the child support, not in regards to his filing status. Why would the court have a concern?
Oh, because the filing status would just be for the tax benefit.
Why would that be a concern to the court?
Because he only gets to see his children every other weekend, and he waived the spousal support and child support.
So you would believe the court instructed him
Yes.
to do head of household?
Either way, this is signed by the court, and it does
Well,
say
again,
that
I get that, but my question is, was it filled out incorrectly?
according to the signatures, it shouldn't have been filled out incorrectly. And
Yeah,
then
okay.
I guess what this would be a case of would he would have to go back and reopen the case, is what you're suggesting, or?
No, I'm suggesting it just incorrectly, and I'm not sure why the court would have an interest in what his filing status is. Thank you.
Ms. Starkey.
Hi, I think that you have made an excellent case for your client. The problem that I see is that in deciding who gets to report what is part of a negotiation for who has to pay what spousal support, who gets visitation, who gets what. And I'm sure the court thought they were throwing your client a bone, allowing him to have the tax deduction. Unfortunately, your client's attorney didn't put it together that he probably wasn't eligible because of the number of days. It's a very, and I don't really think if he had not filed his tax return in a manner that would allow him benefit, that the court would feel that their order had been violated. It was just a privilege or a negotiated settlement, as I see it. And I think, like I said, you've made an excellent case, but not necessarily against the FTB. So I would not be able to support your appeal.
Move to sustain the FTB, deny the petition.
Okay, there is a motion.
Second.
To move to sustain the FTB, seconded by Ms. Stowers. I think without objection, thank you very much.
Thank you for your
coming
time.
in. Thank you.
Thank you.
Okay, next case, Ms. Richmond.
Our next case is B2. Ahmad Ghaderi and Susan L. Ghaderi, please come forward.
Just you?
No, I'm just waiting for one moment.
Where's
Okay.
your buddy?
Apologize.
Okay. Okay. All right, thank you very much. Mr. Eppolite, please introduce the issues in this case.
Good morning, members. There are 3 issues before the board in this appeal. Whether appellants have shown error in the Franchise Tax Board's disallowance of the claimed automobile expense deduction for 2006. Whether appellants have shown that the distributions they received from their wholly owned corporation during 2007 constituted a bona fide loan rather than a constructive dividend. And 3, whether appellants have shown that the Franchise Tax Board erroneously imposed a late filing penalty for 2007.
Okay, thank you. To the appellants, welcome to the Board of Equalization. You have 10 minutes to make your initial presentation and an additional 5 minutes on rebuttal. Please introduce yourself for the record, and then you may begin your presentation.
Okay, thank you. Good morning, Board. My name is Jerry McDonald, and I'm the representative of the taxpayer. We are here this morning as a final attempt to present our position in regards to the transaction in question and why we feel strongly that the transaction should be treated as a loan. The audit of the 2006 and 7 individual income tax return of the taxpayers Ahmad and Susan Ghaderi began in early 2010, a very long time ago. But we have continued to push forward with this issue until we have no other options, as we strongly believe in the transaction being treated as a loan. We have provided the board a narrative of the transaction which outlines a brief history of the transaction and what was occurring at that time that required the refinance of the property and movement of monies to the other entities. It is very important to note the timing of events as detailed in the narrative. Specifically, the refinance of the Valencia property was only done to generate the cash necessary to complete the purchase of the Sand Canyon property. Sand Canyon had already been identified as a development site. Our broker was already in negotiations with the seller, and Centennial Bank had already provided the initial letter of interest prior to this refinancing occurring. We would like to stress again that the original intent was to have the monies move between the entities and not to the shareholder, but the lending arrangements required that the monies be reflected as coming from the shareholder to the new entities. As a result, the monies were loaned to the shareholder, who then loaned the monies to the new entities. We would also like to indicate that at no time prior to this transaction or at any time after has the shareholder taken any dividend distributions from any of the Ashton entities. Also included in the package provided was documentation regarding the auto expense deductions for year 2006. The taxpayer was finally able to locate the canceled checks to support the auto expenses, and we are respectfully requesting consideration be given to these expenses. The original audit had disallowed approximately $1.6 million of consulting expenses. We were able to substantiate all of these expenses, resulting in no change to consulting expense deduction, and we feel the attached substantiation of the auto expenses should be sufficient to allow deductibility in 2006. Finally, a late filing penalty was assessed for tax year 2006. Though the FTB indicates the return was received after the due date, we stand by our position that the return was prepared by the extended due date of October 15, 2007. We do not know what occurred with the original mailing of the return, but ask that strong consideration be given to the filing history prior to 2006. We have enclosed in the package a summary provided by the FTB of filing dates of the taxpayer returns for the previous years. I personally would like to thank the board for allowing us to present our case this morning and hope you will consider the information provided in arriving at your decision. Mr. Ghaderi would like to present some information to you now. Thank you.
Thank you. Good morning.
Good morning, Madam Chair and members of the board. Thank you for your time today. We've been working, first of all, my name is Ahmad Ghaderi. We've been working with the Franchise Tax Board for several years related to the audit of our personal taxes. All individuals from FTB that we have interactions with have been gracious and helpful, and I want to thank them for that. I've broken my comments into 3 sections. Auto expenses. As Mr. McDonald mentioned in his statement, during the past 2 years we have provided substantial documentation to substantiate our deductions, namely our payments to our consultants and on auto expenses, which FTB originally declined to accept. FTB has already accepted the information regarding our outside consultants. Regarding our auto expenses, we have been able to find copies of our auto expense checks for 2006, which also substantiates the auto expenses that we had listed. In fact, we have more auto expenses than we had reported. I have already submitted 14 copies of the auto expense table, including copies of the cash checks. Based on this, I respectfully ask that the board eliminate the entire 2006 tax assessment and related penalties and interest. Second item, refinancing of our Ashton development property. My wife and I started development of our gas station properties in late 90s. In January of 2006, we identified Ashton Sand Canyon property as one of the locations which we wanted to acquire in order to expand our business. As part of our negotiations with the Sand Canyon property owner required confirmation of funds and loan approval prior to entering escrow. We contacted our lender who had the loan on the Valencia site and worked with them to obtain approval regarding the refinancing of the Valencia site and used portion of the equity that we had built to buy the Sand Canyon site. Once we were able to obtain bank's approval, we finalized our negotiations, finalized the loan, and entered escrow to purchase the Sand Canyon property. As part of the loan process, since Ashton Valencia and Ashton Sand Canyon were set up as different entities, and my wife and I had to sign personal guarantees for the loan, we could not simply have the funds move from Ashton Development Valencia to Ashton Sand Canyon. Our lender had to give us the funds, and then we loaned it to Ashton Sand Canyon in order to buy that property. At no time were the funds used for personal use. Funds were used for expansion of existing operations. We did not use it as a deduction for Ashton Development. The loan should not be considered a constructive dividend in that based on the loan documents that we supplied to FTB, there was and still is an expectation and anticipated repayment of the loan to Ashton Development by Ashton Sand Canyon. Contrary to FTB's contention, we have never collected any payment or dividends from Ashton Development. Ashton Sand Canyon has not been able to this date pay any payments to Ashton Development or my wife or I. Security and collateral was provided for the loan, being the Sand Canyon property itself, as well as the personal guarantee that my wife and I signed on for the loan. As shareholders of the Ashton Development, we could not make any payments to Ashton Valencia since Ashton Sand Canyon was not in a position to pay us, whereby we could not pay Ashton Valencia. Contrary to FTB's claim, I'm not the only shareholder of the company. My wife is also an officer of the company, and the funds were used to expand our business and not for personal use. Contrary to FTB's claim, there was a ceiling as to the amount that the corporation advanced, and that was based on the equity of the business and based on bank's appraised value of our asset. As FTB has indicated, we did record this transaction on our tax returns. That should be more than sufficient to qualify as recording the transaction. There is and there was a set maturity date set on our loan document, which was at the time of the sale of the Sand Canyon property. Please keep in mind that to this date, Sand Canyon property is still not profitable. We respectfully make the same claim as related to Ashton Development El Toro, that the funds loaned to our El Toro entity was also for the expansion of our business, and all the items mentioned earlier apply to this site as well. Based on this, I respectfully request that the board consider the funds from Ashton Development as a loan versus dividend to the shareholders and abate the 2007 tax assessment and related penalties and interest. Late filing. I have no reason to believe that Mr. McDonald would not file our 2000 tax return with FDB in a timely manner. I deal with a lot of government entities because of my engineering company, and there are times when mistakes are made by government agencies, and FTB is no different. As Mr. McDonald indicated, he has clearly shown documentation that we had filed our paperwork on time, and I find it hard to believe that if we had not filed our paperwork with FTB, that FTB would wait close to 6 to 7 years to reach out to us and suddenly assess a late penalty. In closing, my wife and I took the risk of refinancing our property and investing into two businesses that unfortunately have not been profitable since day one, and our investments took place during the harsh recession period that many businesses, and we were no different, went through, starting in late 2007. We have worked hard and put every penny into these two businesses and kept them running. I did not take a shortcut of filing bankruptcy or go through the foreclosure process, which unfortunately many had. I respectfully request that the board look at our case based on the business intent of this transaction versus the documentation aspect of the transaction, and abate the assessed taxes and related penalties and interest. Thank you.
Okay, thank you. Franchise Tax Board, please introduce yourself for the record and then begin your presentation. 10 minutes.
Thank you. Good morning, Chairwoman Ma and members of the board. My name is Suzanne Coakley, and I'm representing Franchise Tax Board. Also here is Chiro Immordino. There are 3 issues for your board to decide in this appeal. The first issue is whether appellants received loans or constructive dividends from Ashton Development. The second issue is whether appellants have substantiated a claimed business expense deduction in 2006. And the last issue is whether appellants had reasonable cause for filing a delinquent income tax return for 2007. The first issue is whether appellants received loans or constructive dividends from their wholly owned corporation, Ashton Development. Appellant husband was president and sole shareholder of Ashton Development, a C corporation in the business of retail gas stations. Ashton Development transferred funds of approximately $2.3 million to appellant husband as its sole shareholder. Appellants contend that they invested monies into two newly created business entities several months after they received the funds from Ashton Development. Appellants appear to argue that this somehow proves that the distributions to appellants are loans. For tax purposes, the difference between a loan and a dividend is material, because dividends are taxable, whereas loans are not taxable. Courts have applied a list of factors in order to determine whether a transfer of funds is in fact a loan or a dividend. After reviewing the factors applied by courts, including the Ninth Circuit, respondent determined that the transfers of funds were constructive dividends from Ashton Development for the following reasons. Number one, appellants controlled Ashton Development and authorized all transfers of funds from the corporation to themselves. Number two, appellants did not provide collateral for the transfers of funds. Number three, appellant provided two non-interest-bearing promissory notes with no terms for repayment. The first promissory note for approximately $1.9 million was created 7 months after appellants received the funds from Ashton Development. Number four, appellants did not pay interest on the funds they received from Ashton Development. Number five, appellants did not at any point in time repay any portion of the funds from Ashton Development. And number six, Ashton Development did not provide terms for repayment and did not force repayment of the funds it transferred to appellants. Lastly, the fact that appellants invested monies into two newly created business entities several months after receipt of the funds from Ashton Development is a separate transaction with a separate tax effect. Courts would not consider the separate transaction in determining whether the distributions from Ashton Development to appellants were a loan. To suggest otherwise is an incorrect application of the law. In addition to the factors already discussed, the standard courts often use is whether this would occur between two unrelated taxpayers. For example, or two unrelated parties. For example, would a reputable financial institution loan $2.3 million to appellants with no interest, no collateral, no terms for repayment, no repayment on the loan at all, and no promissory note at the time of the transfer for the majority of the funds? The logical and reasonable response is no. Based on the law, the distributions from Ashton Development to appellants are not loans, but taxable distributions known as constructive dividends. The next issue is the business expense deduction. Appellants claimed an expense deduction of approximately $1.3 million on their federal personal income tax return related to appellant husband's wholly owned S corporation, A&S Engineering. At appeal, respondent allowed over 90% of appellants' claimed deductions with the exception of the automobile expense deduction. The amount at issue can be broken down into two subparts: claimed expenses related to lease payments for cars and mileage reimbursement. Respondent requested substantiation for these items at audit, protest, and appeal. Respondent was more than willing to look at any new documentation to try to allow the expense deduction. Until this morning, appellants have provided nothing to support the lease payment expenses and have provided only a handwritten schedule for the mileage reimbursement with no corresponding checks to support it. Instead, appellants submitted 3 unrelated checks to support mileage reimbursement, but there are problems with these checks. Number 1, the checks appellants submitted are not on appellant's own schedule. Number 2, the checks on their face do not appear to be for automobile expenses for A&S Engineering. And number 3, the checks submitted total a little over $1,000, or just a fraction of the expenses claimed. In addition, this morning, appellants have provided another schedule with checks. I would be happy to review this in more detail if your board so desires. After a brief review, I can tell you that there appear to be at least a few inconsistencies. The first one is that the original amount of the auto expense at issue is different than what they claimed on their income tax return. Second, there appear to be at least 4 checks that are for the wrong year, for the 2005 tax year instead of 2006. It is well-settled law that the taxpayer has the burden of proving an entitlement to the deductions claimed, and that unsupported assertions are not sufficient to satisfy a taxpayer's burden of proof. Because appellants have claimed an automobile expense, they must meet the basic requirements of an ordinary and necessary business expense, as well as the more stringent substantiation requirements of Section 274 of the Internal Revenue Code. Appellants have not met their burden due to the fact that they have, throughout this process, they have provided nothing for the lease payment expenses and only a handwritten schedule for the mileage reimbursement expenses. Therefore, at this point, respondent maintains its position that it correctly allowed over 90% of appellants' claimed expense deduction related to their S corporation, A&S Engineering, and disallowed only the portion that appellants did not properly support or substantiate. The last issue in this appeal is whether appellants have established a reasonable cause for filing a late return for the 2007 tax year. Appellants filed their joint income tax return for 2007 on October 15, 2009, nearly 1.5 years after its due date. Respondent imposed a late filing penalty because appellants filed a joint return after the due date for 2007, and appellants did not provide reasonable cause for filing a delinquent joint return. This is supported by the Board of Equalization Appeals staff summary, which provides that appellants never asserted grounds for abating the late filing penalty for 2007. Therefore, respondent cannot abate the late filing penalty. In closing, I ask your board to sustain Respondent Franchise Tax Board's position. Thank you.
Okay, 5 minutes on rebuttal.
The only thing I'd like to ask the board is, based on what both myself and Mr. Ghaderi mentioned in our opening statements, is to look at the entire transaction with regards to the loan, the January 2006 date through when the property closed in 2007, as to why it was necessary to move the monies out of the Ashton Valencia Corporation to the shareholders, but then shareholders not immediately, but subsequently loan that money right back to Sand Canyon, which was the original intent to go from Valencia to Sand Canyon. So I think by looking at the entire time period and purpose of why it was done, I think the intent of it, was for it to be a loan and not a constructive dividend.
The only comment Jerry has already commented, and I read in my comments to the record. As far as the auto expenses, we have documentation for every auto expense that we have, and related to A&S Engineering. These took a long time to research and find. My apologies to FTB, but I would request that they be reviewed, and they'll find out that there's more auto expenses than we had reported. So I appreciate their re-review of those documents. Thank you.
Questions? Ms. Harkey.
For the appellant, hi.
Yes.
On the FTB, on the auto expenses, I am willing to consider these, but the FTB pointed out some glaring inconsistencies that you may or wish to withdraw. On check 4221 on 3/9/2006 and 3/9/2006, 4222, 4223, and 4470. Those are Longo Toyota and then GMAC. Those are dated 05. And it looks like I would suspect that you took the expense or the write-off in 05 and probably not in 06. So I'd suggest you, if you can offer an explanation of that sometime before this hearing is over, that would be good. The rest of them seem to be valid and perhaps considerable, but why did these take so long to surface?
First of all, to answer your question, if you don't mind.
Sure.
On those items on the 2005, again, I just had my staff, the checks, my original office manager who was with us 2006. When she left, we couldn't simply find it. Just that's what it is. Couldn't find it. And then as we got closer to this hearing, we searched all over the place, and finally we were lucky to find these checks. In fact, I have requests made to Bank of America to find these checks for us, because the documents that we give to Jerry when he files his taxes are based on these checks. Bottom line, we found the checks, and again, my apologies to FTB if we didn't do our research ahead of time. But as far as the 2005 checks, again, I had, when they found the checks, anything that was cashed in 2006, that's what they put in here for me.
Okay, so it is conceivable that these 2005 checks might have been or should have been omitted.
I got to double check. You might.
Can I?
I'm sorry. Go ahead.
Sure.
Say
Thank
something?
you.
Thank you. What his staff, how they would provide information back in those early 2000 years is they would prepare a schedule, not on the date on the check, unfortunately, but when they received the checks back from the bank. So the fact that, you know, and I haven't had the chance to go back and cross-reference 2005 because I just got a copy of this yesterday also. So it is possible that though they have a late December 05 date on them, that they were not deducted in 05, because when she prepared the hand schedule to provide to me to prepare the return, that it had a clearance date of 06, and it was included on the 06 and not the 05. So that is an explanation, but I can't tell you one way or the other if that existed.
Okay, thank you. Yeah, I happen to have some experience trying to find old records, and it's very, very difficult, very time-consuming, especially with a bank like Bank of America that's got so many, it's just very difficult. It's hard to get anyone to even accept the order, let alone to comply with it.
Absolutely.
But it's very tough. So I do have some sympathy for this, and I would personally like this looked at and considered. The next though, I've got a problem with the loan or the dividend, as the case may be. It indicated that you received the monies and then seven months went by or more before you actually loaned them. How did that work out?
Well, we were going through the escrow process. As I mentioned, when we, in order for us to purchase the property, the seller wanted to have confirmation of the funds and also the loan approval before he would enter into escrow with us. We had to obtain the approval for the loan had to be funded, and then we entered escrow, and then the funds had to be sent over to Ashton Sand Canyon.
At the time of closing, and it
Yes,
took you roughly 7 months to close?
It's because of due diligence as far as it's a 20-acre property, and there are 3 different, entities businesses on it, a mobile home park, a gas station, and a small closed office building. So we had, it's quite a bit of endeavor to go through it, and we had to get approvals from, the operators and what have you. So it literally took about 6-7 months.
Reports.
Yes, ma'am. And again, this is next to the watershed area that we had to get Army Corps of Engineers involved. Not necessarily get approvals from them, but do our due diligence, and it takes time to get the approval.
Okay, so they required that you have funds on deposit prior to even opening an escrow?
Yes, ma'am. It was a big transaction. It's approximately $7 million, and they didn't want to waste their time, going into escrow with somebody that might not have the funds.
Okay, did the other entity, let me see which entity, let me see, Sand Canyon property. Money got loaned
Yes.
to Ashton. Here's what you're saying. Money got loaned to Ashton to buy Sand Canyon.
Yes, ma'am.
Okay. Did Sand Canyon ever make any interest payments or anything to Ashton?
No. They're not in a position to do so.
Was the note documented such that there was an interest to be charged?
Don't have the document in front of me. My apologies. I don't recall.
The FTB is saying that was not.
Okay.
Okay. And there were no payments made, there were no dividends or to date, no payments or repayments from either you or Ashton or Sand Canyon, excuse me. Okay, I've got a little bit of a problem with the loan only because of the legal requirements for tax purposes. But I really do believe that these ought to be considered, and I'm sure the FTB will take that into consideration. Thank you.
Thank you.
Okay, Ms. Stowers.
I just have a quick follow-up question on regarding the automobile expense. Ms. Harkey pointed out 4 checks that are dated in 2005, and I also see one check 4014 dated in 2005, the very first check. My question is actually with respect to the law, so I will go to the Franchise Tax Board first. If the checks are written in 1 year but do not clear the bank until the subsequent year, under the law, which year do you claim the deduction?
Generally, under the rules of constructive receipt, those checks will be credited to 2005.
Okay. So that will mean, under the law, 4014, 4221, 4222, 4223, and 4470 would not be automobile expenses for the 2006 year.
I think there's one more, too.
And there's one more?
4090.
4093. So to the Franchise Tax Board, during the course of your audit for the automobile expenses, you were trying to verify the expenses actually took place. Did you come to a conclusion that they were ordinary necessary business expenses?
So originally, the expenses were listed as other expenses on the tax return. So when we got information from appellants that there were consulting expenses, mileage reimbursement, lease payments, then we asked more questions regarding the consulting expenses. That was the majority of what they were claiming. And they were able to substantiate all of that. With regard to the automobile expenses, they were never able to explain why A&S Engineering had automobile expenses for that particular entity. They also were not able to substantiate any of the expenses that they were claiming. They gave us a handwritten schedule originally. They claimed that they would be able to substantiate the lease payments, that they had checks from the bank, and they just never provided them to Franchise Tax Board. As far as mileage reimbursement, they did provide a schedule. And then at appeal, they did provide 3 checks, but 3 checks were not on their own schedule. And just looking at the checks, it was very difficult to determine whether this was even for an automobile expense.
To the appellant, can you speak to the ordinary necessary business expense for the automobile? Are you prepared to talk about that?
Explain how. Sure. As far as the mileage reimbursement, as you can see on the table that we provided you, there's different names of my employees. As part of our business for A&S Engineering, we travel to a lot of agencies to obtain approvals for our projects. And these reimbursements are for their mileage reimbursement as they drive through the city, mileage payments. And so these are all substantiated with the checks that we wrote to them every month for the expense that they turned in. And then as far as the vehicles, there are vehicles for myself, for my wife, and one of our other members of the office. That's what those car payments, they're lease payments that we made to the corporations for cars that we drive, as well as the car payments that you see on this list.
Okay. I think Ms. Harkey covered the loans or dividends to shareholders and concluded that nothing has been repaid yet and no interest. With respect to the late tax return, is it your argument that the tax return was filed timely? Or
Yes, ma'am.
Correct.
Yes, ma'am.
You
And one of the documents that I provided in the paperwork, I had asked the Franchise Tax Board for a history of filing, and if you look at all the years prior, a good majority of them were April 15th, with the others being October 15th. So the history of the taxpayer up until that point was timely filing.
I understand
Why it wasn't recorded, I can't speak to that.
Okay, thank
but
you.
that's our position.
You have a history of timely filing. To the Franchise Tax Board, they do have a history of timely filing. Do you have a copy of the tax return in your exhibits? When was the tax return signed?
Can I comment on whether they've filed timely
Yes,
returns?
please.
Thank you. So for 2006, they filed an untimely return. It was in November of 2007. The 2007 return was not filed timely as well. On the federal side, we were able to get a federal transcript. The 2006 return was filed late on the federal side, and for the 2007 tax year, the return was not filed.
At all. Okay. So,
But what I was speaking to was if you look at the 96, 97, 99, 2000, 2001, 2005, 2008, 2009, 2011, 2012, they're all timely filed, supported by this document.
I understand what you're saying.
So as to what happened in '07, I don't know. I
Okay,
mean,
so
as to why.
I
it
understand.
was-
So they have a history of filing timely, but for the '06 and '07 return for California, they did not file a tax return on time, and they were late for the federal return and did not file a federal return. And as we
That
know,
I'm-
each year
I-
stands on its own. Thank you, sir.
Mr. Renner.
The distribution, in terms of the loan, and the timeliness of it, or the amount of time, you were saying that the money needed to be deposited?
Yes, sir.
In order to, as earnest money, I suppose, for some transaction that was about to take place?
Yes, sir.
Deposited where?
In an account. But in this case, it had to be in our account because of the fact that we got the loan.
You had to demonstrate in your own accounts that you had the money?
Yes, sir.
They didn't require you to put the money anywhere else?
No, it required at that time that it had to be in our personal account and then loaned back into St. Kane.
And do you have any documentation of that correspondence in regards to how that was done, or how you demonstrated that, or that requirement that they had asked you to do that? Anything that you've got to help us see that that was indeed a requirement of your transaction?
Unfortunately, I don't have documentation. And the person who did the loan broker who did our loan through the Centennial Bank, unfortunately, has passed away. And unfortunately, I don't have any documentation. It mostly was verbal, and if there was any documentation, he's the one who had it. So my apologies.
Let me just ask, in regards to the auto transactions, let me ask FTB. In your review of those, are you going to be able to review those in a satisfactory setting for yourself? How are you going to be able to review that right now, as opposed to, for instance, us granting a 30-30-30 on the tax on the auto expense issues? Since you just received this too.
Yes, I think I would need time to be able to go through it in detail.
So move.
I assume that how narrow you want to make that?
Just the auto.
Okay. So I guess there's let the chair take that.
Yeah, so.
Take a motion?
Well, I mean, are we done with the questions before we? Okay. Well, I just want to go on record also that I'm sympathetic to the auto expenses, and I understand that it's not easy to get checks from the big banks especially. So I'm sympathetic, but, disallowing the checks dated in 2005. I'm also, unfortunately, being a CPA, if we're going to be doing a loan, normally you either have minutes of meeting, you put it in there, you have the loan documents, there's a 10-factor checklist that courts usually consider, to be a loan versus a distribution, and all the things that I think some of, Ms. Harkey mentioned. Is there, maturity dates? Is there, interest to be paid? Were you booking the interest, even if it wasn't, done, but just keeping track of it in some sort of record book and actually booking it on your tax returns, I think, would have been a lot more persuasive to me. So that's where I am. Oh, Mr. Horton.
Thank you, Madam Chair. I might suggest that the department take a moment or two and share with the taxpayer the conditions upon which the automotive expense would be deductible, just in case they need to acquire additional information or additional documentation to support their transactions. The check in and of themselves as I reviewed them, did not seem to have enough information, but possibly further clarification of what those transactions entailed might be helpful to the department in determining whether or not they are allowable. I would also suggest to the department that discussions about alternatives, hypothetical alternatives that the taxpayer could have engaged in, such as making the payment directly to the company, as opposed to taking it out to themselves and then executing the transaction and the timeliness thereof.
Well, yes, we'll be very happy to do that.
Thank you.
Okay. Ms. Harkey.
I think their argument about borrowing the funds is a good one. Unfortunately, it doesn't stand up for tax purposes, but I do believe that the bank probably required them to borrow and guarantee personally. And I'm assuming you had money sitting in an account that you could have verified. But even that being said, the fact that there was no interest and no specifics on the notes and other things would create a problem for tax purposes. So, next time.
Yes, thank you.
Thank you.
Okay, so there is a motion. I heard a motion.
I'd like a motion to.
Let's go ahead and go through the whole thing, yeah.
Yeah,
Okay.
let's go for.
A motion to support the department with the exception of the auto expenses, checks that were supplied today to be examined on a 30/30/30, and that means get back to the board. 30 days for the taxpayer to supply any information, 30 days for the FTB to review, and then 30 days to get back to the board.
Is there a second or? Oh.
Might I make a recommendation to the members?
You may.
That we bring this back as a proposed summary decision in this instance, that we do additional briefing, having the Franchise Tax Board go first with additional briefing, analyzing the taxpayer submission, and then it goes to appellants to respond, and then appeals writes up a proposed decision for the board's adoption. Well, we'll hear everything that the board has to offer, obviously, when you're done with your discussion. So we hear your everything you have to offer, but I'm sensing that you have a conclusion you're about to reach, but that we have just this one
Right.
thing that you want still.
The order is important, and I think you're
Right.
right. The order should be that the
Right.
FTB review what was provided.
Right, it sounds like you just have this one part that still needs to be resolved.
Right, and so it's only the auto
Auto that
expenses
needs to be
that
resolved.
we need to be
Right.
resolved. The rest of it, we have agreed, or I've made a motion to
Right.
support the Franchise Tax Board.
Right, it looks like that you just have this one discrete issue that needs to be resolved, so that in this instance, it does need to come back to the board.
It does?
Does not. That
Does not.
in this instance, it looks like we can write a decision after this additional briefing process. So it'll come back on the adjudicatory calendar after we draft a decision after the additional briefing process.
So it'll be quicker for the taxpayer instead of, 30
It'll-
days and coming
right.
back in 90
Right.
days, that they can, once
So-
they review and make a decision, and
Right.
we can just do the write-up.
So-
and-
My question, though, is, does the taxpayer, if the taxpayer doesn't agree with the final appeal, do they have the right to bring this back to us?
Sure, because there's always the option of a
Okay.
petition for rehearing at the end of the day. But they'll still have, the additional briefing process to provide their input.
Right,
That's-
I just always like to be sure that they are heard, and they know that if they don't feel they're heard, they can come back to the
Absolutely.
board.
Through the additional briefing process, they'll still have their input. But at this point, I'll stop talking, but
Okay.
I'll let
me
you
just ask-
continue.
I have a question in regards to that. Let me ask you a question in regards to that.
Yes,
So what basically saying is
I don't think
it's not a
we-
30-30-30.
It will be a 30-30.
It is a 30-30-30, but not a continued hearing?
Correct. Because it sounds like you just need to have this one analysis
Because
done
we do
of
not
the-
have the ability to bifurcate this one particular item.
Correct.
To be coming back to the board on its own.
Right.
We would be having to have the whole issue come before us. So in order to move forward, we're better off to go ahead and do it as a 30-30-30 with some discussions with our instructions just to focus on the auto issue.
That's correct.
And then that would be coming back to us then on a H calendar or something.
Correct.
And then
We'll-
if indeed.
We'll write it up with all the direction you're giving
And
us
then
on
if
all
in-
the issues.
And if indeed then the taxpayer does not agree with the portion of it that we are asking FTB and the taxpayer to deal with, their path back to us then is for a rehearing.
Correct.
Okay, I got it.
Because they're still sitting
So
here
does
now.
tell me about the motion then. How?
Okay, so this is what I have.
Can you phrase the motion? No,
Okay, so
okay.
Ms. Stowers has been typing.
I have a motion for a 30-30-30 for additional briefing on the automobile expense item and for it to come back to the board on a summary decision H calendar.
Correct.
Second.
Okay.
I
Without
would
objection.
still recommend that you detail to the taxpayer, what your resolution of the late filing penalty
Oh, right now?
issue is, and as far as
Okay, so-
on the dividend loan issue is as well, how
So
you're
I-
resolving those issues.
Okay, so, well, in the motion, I think we are sustaining the FTB on the loan issue as well as the late filing.
Correct.
However, the auto is what we would like the Franchise Tax Board to go back and review the taxpayers' records. And that will be in the 30-30-30 proposed decision written up by the appeals to be reviewed and approved by the taxpayer. If not, the taxpayers can come back for a rehearing on that issue.
Correct.
Okay.
That is the motion.
That's the motion.
Crystal clear.
Thank you.
Go do your research on your auto expense.
Okay. All right. Thank you very much.
Thank you.
There was a motion, yeah.
Yeah, we did a second.
Motion and a second. Well,
Well,
I
there
said
was
without
no
objection,
objection.
so.
Okay, gotcha. Got it.
Unless you object.
No, I just didn't hear the question.
Thank you.
Thank you.
There was a lot going on.
Okay.
Yay, one done.
All right. Ms. Richmond, next item.
Our next item is B5, Alan R. Brayton. Please come forward.
Okay. Uh, Okay, Mr. Thompson,
Good morning.
please introduce the issues in this case.
The sole issue in this appeal is whether appellant has shown error in respondent's determination that there are not grounds to abate the accuracy-related penalty.
Okay. To the taxpayer, welcome. You have 10 minutes on your initial presentation and then 5 minutes on rebuttal. Please introduce yourself for the record, and then you may begin your presentation.
Good morning, Richard Carpenter, representing the appellant. Mr. Brayton is here also. I'd like to thank the board for allowing us to make our presentation today. We are here to determine whether or not the accuracy-related penalty imposed by the Franchise Tax Board against the appellant for tax year 2004 should be abated or not. The accuracy-related penalty that the FTB asserted against Mr. Brayton exceeds $900,000. So who is Al Brayton? Mr. Brayton graduated from the United States Air Force Academy. He was commissioned as second lieutenant upon graduation, and he spent the next 12 years on active duty serving our country. Today, he is a California personal injury attorney who represents victims of asbestos-related diseases. The relevant California law is Section 19164 that provides for an accuracy-related penalty to be imposed and determined under the provisions of the Internal Revenue Code, Section 6662. That section authorizes a 20% penalty on underpayment of income tax that is attributable to a substantial understatement of tax. Under Code Section 6664C1, the accuracy-related penalty will not be imposed with respect to any portion of an underpayment if it is shown that there was reasonable cause and the taxpayer acted in good faith. Under case law from the U.S. Tax Court, in determining whether or not a taxpayer has properly shown reasonable cause and good faith, the court has looked to three factors. Number one, whether the advisor that the appellant relied upon was a competent professional who has sufficient expertise to justify reliance. Second, did the taxpayer provide the necessary and accurate information to the advisor? And third, did the taxpayer actually rely in good faith upon the advisor's judgment? We are dealing with tax year 2004. However, the journey to get to 2004 began back in 2002. Mr. Brayton began to seek out tax and estate planning assistance. Although he was a successful personal injury attorney, he lacked any understanding about tax matters, so he sought the advice of professionals. He went through a list of 5 different professionals that he relied upon. The first one he relied upon was Matt Flammer, a CPA in the state of Texas, a graduate of the U.S. Military Academy at West Point, and a MBA with a 35-year career working in the accounting field. Number 2, he advised and relied upon Joe Garza, a licensed tax attorney who has been an attorney in the state of Texas for an excess of 40 years and has prepared approximately 3,000 estate plans for high net worth individuals. Number 3, he relied upon Cameron Harris, a licensed attorney in the state of Texas who has an LLM degree from New York University, which is the premier tax law program in the United States. Number 4, he relied upon Terry Cumbley, a CPA, whose firm is affiliated with McLabry, the 5th largest accounting firm in the United States. And finally, he relied upon Joe Petrocelli, a licensed attorney in the state of California who has an LLM degree from the University of San Diego. Mr. Brayton spent 2 years seeking out tax and estate planning. He met numerous times, in excess of 6 times, with Mr. Garza. He had numerous discussions with other attorneys, other professionals, before he implemented any of his estate planning recommendations. In addition to that, before filing his tax return, Mr. Brayton took the additional step of hiring Joe Petrocelli to review the entire transaction and write an opinion letter before he filed any tax return. He consulted with 5 different tax professionals. Mr. Brayton would like to make a statement concerning his reliance upon professionals.
Thank you, Madam Chairwoman, members of the board. My name's Al Brayton. I guess I acknowledge that I'm a successful personal injury attorney. I'm also a successful businessman running a rather large firm, and I attribute that primarily to surrounding myself with good people. My CFO has been with me for 18 years, Matt Flumer. I charged him with going out and finding somebody to give estate planning and tax advice. He came up with Mr. Garza and Mr. Harris. They provided references. He checked their references. And we moved forward. The transaction that they put together was very complicated. It involved 6 different family trusts, breaking my practice into 6 different LLCs to manage different areas of the practice: facilities, accounting, HR, investigations department, things of that nature. It also involved some currency-linked deposits that I can't come close to explaining how those derivatives work, but I was assured by about 3 different CPAs that they were fine. When all this was done, I also went out and had an independent opinion done by Mr. Petrocelli. I relied on them. I think I did everything that I should have done to look at the transaction, and we moved forward. It didn't work out well, and when the Franchise Tax Board took issue with it, I went out to yet another attorney and 2 other CPAs, and when they came back with their opinions, we decided to just pay the tax and not contest anything further on that part of the transaction. However, I do think that as far as relying in good faith on the professionals that I vetted, that I did act in good faith, and the bulk of the estate planning work is still in existence as the trust still exists and are funding the educations of children and grandchildren.
I also want to point out that the U.S. Tax Court has made numerous case law concerning whether a taxpayer has acted in good faith and reasonable. And one of the factors that the court has indicated is the taxpayer's sophistication with respect to tax law. I've cited 3 different U.S. Tax Court cases in my briefs, Ruckman, Conahan, and Gray, which also, again, references sophistication with respect to tax law. Mr. Brayton didn't have sophistication with respect to tax law. He went out in a 2-year journey, hired numerous professionals, checked their references, and did what he felt was the proper steps that needed to be done. Thank you.
Okay. Thank you. Franchise Tax Board, please introduce yourself for the record and commence your presentation. You will have 10 minutes.
Good morning, Chairwoman Ma and board members. My name is Eric Yadao. Sitting with me is Marguerite Meunier. We represent Respondent Franchise Tax Board. And the issue before your board is whether the appellant has established he is entitled to an abatement of the accuracy-related penalty. And the answer to this question is no. We agree that the appellant is a very successful litigation attorney and a successful business person who is well-educated, having earned degrees in economics and finance. So for the tax year 2004, the appellant was anticipating reporting substantial taxable income, but instead entered into a tax avoidance plan that he purchased from a Texas attorney for a fee of $675,000. Under this plan, the appellant established an S-Corp and 6 LLCs, and the S-Corp hired the LLCs to provide management services back to the S-Corp for a fee of $49 million, and the LLCs hired the appellant himself to be the person to provide those management services back to his S-Corp for a fee of $180,000. So for an exchange in value perspective, the appellant paid $49 million for management consulting services that he himself provided to himself for $180,000. To sum up the transaction, the management services were provided to appellant, for appellant, by appellant, to avoid payment of $4.5 million in tax on the unreported $49 million in income. And of course, that audit did not withstand scrutiny, and the appellant couldn't substantiate it. That amount, the $49 million, was disallowed and attributed to the appellant as income. Although he has not, our record shows that the appellant has not made any payments on that tax, but he does not dispute the tax as part of this appeal. He only disputes the application of the accuracy-related penalty. As your board is aware, under the law, the accuracy-related penalty may be abated if the appellant can establish that he reasonably relied in good faith on the tax advice of a professional. And the appellant's reasonable reliance and good faith argument fails for a number of reasons. First, the Texas attorney, Garza, who developed the plan, is a promoter of tax avoidance plans, who economically benefited from the appellant's participation in the plan. Recall that he paid Garza $675,000 for this plan. Case law holds that this creates an inherent conflict of interest and completely discredits the reasonable reliance on a promoter on that plan. And the same conclusion is true of any reliance asserted on Mr. Garza's business associate, Cameron Harris. The same conflict of interest exists. Second, the appellant alleges reliance on his CPA, Mr. Cumby, who prepared the returns. However, that reliance also fails because the CPA's affidavit that's in the record states that when questions arose regarding the underlying transactions, he relied on Garza. And of course, Garza's going to advocate his plan and advise the CPA that these are valid expenses, which we know now that they're not. The appellant then suggests that he relied on the opinion of a second attorney, Mr. Petruccelli. However, Petruccelli's letter is based on ambiguous facts and assumptions, and it does not in any way address the S-Corp's $49 million deduction. Petruccelli's letter is further discredited because he was referred to appellant by Garza for the express purpose of validating Garza's tax avoidance plan, and this evidence is found in Garza's affidavit in the record. We have it as Exhibit I of our opening brief, paragraph 9, where Garza states he referred Petruccelli to the appellant. As set forth, the appellant's reliance arguments fail independently for the reasons stated, but they also fail collectively because the assurances received seek to validate the opinion and the tax avoidance plan of a promoter. Case law is clear on 2 points. 1, a promoter's opinion cannot be relied upon in good faith, and 2, any other advisor's opinion must be independent of the promoter, and that cannot be said to have occurred here because they all relied or were referred to by Garza. To say this differently, case law stands for the principle that if a promoter's assurance of his plan cannot be the source of good faith reliance, then that same plan cannot be validated by a later opinion that was referred to the taxpayer by the promoter. In any event, if there were any doubt by your board, respondent restates the essential fact that none of the opinions received addressed the deductibility of the S-Corp's $49 million expense deduction, which is the basis of the penalty here. And essentially, the appellant asserts that he relied on an opinion that he was never given because none of the opinions touched on the $49 million deduction. Respondent would note that the appellant has argued that he lacks any understanding about tax and financial matters. He's never taken an accounting course, and therefore his ignorance further asserts his reliance argument. Notably, the appellant has offered 3 authorities that suggest your board's focus should be limited to the taxpayer's knowledge in tax law. While knowledge of tax law may be relevant, the analysis of facts and circumstances neither begins nor ends there. The 3 cases cited by the appellant can easily be distinguished. These were all taxpayers who prepared their own returns and fell under some sort of physical or mental illness, and therefore they made errors on their returns, and the tax court returned the conclusion that because of these illnesses that it was reasonable that they made these mistakes because of their lack of knowledge in tax law. The authority that your board can and should rely upon is found in the federal treasury regulations underlying the accuracy-related penalty, and it states expressly, the taxpayer's education, sophistication, and business experience is relevant in determining if the reliance on the tax professional's opinion was reasonable and in good faith. We would restate for your board that the appellant's an incredibly successful businessman. He has a degree in economics. He has a degree in finance. As I close my presentation to your board, I would note that the appellant has also cited a case law called Neonatology versus Commissioner. We've also cited to that, and we agree with it, especially where that case states in relevant part, when a taxpayer is presented with what would appear to be a fabulous opportunity to avoid tax obligations, he should recognize that he proceeds at his own peril. As highly educated professionals, the individual taxpayers should have recognized that it was not likely that by complex manipulation they could obtain large deductions for their corporations and tax-free income for themselves. Like the taxpayers in neonatology, again, the appellant is a very intelligent, incredibly successful business person. Your board should find that the appellant, understanding the risks, proceeded at his own peril. And as I conclude, I would like to just state, I looked in because our penalty follows the federal law, so I was looking about the purpose and the application of the penalty, and I looked at language used by federal lawmakers as they advocated for amendments to the law in its existing form, and they described the penalty of the purpose as to deter taxpayers from playing the audit lottery by taking questionable positions on their returns in hopes their aggressive positions will go undetected. We believe that it's the case here, and we ask your board respectfully to sustain our penalty.
Thank you. Okay, so taxpayers, you have 5 minutes on rebuttal.
The FTB is pointing out that the appellant is highly educated. He has a basic law degree. He went to West Point. He went to the Air Force Academy, served in the Air Force for 12 years. He may have some economic and finance background, but it doesn't mean that he remembers classes that he took 35 years ago. He did what he felt was prudent. He surrounded himself with what he felt was professional, qualified people. He checked references. He took a 2-year journey. He didn't just jump into this in a 2-week process. He took a 2-year journey to do this. Looking back with 20/20 hindsight, the planning turned out not to be proper, and Mr. Brayton acknowledged that. However, it doesn't change the fact that he relied upon professionals and his reliance was justified. Thank you.
I would just like to add that Mr. Garza, the determination of him as a promoter came in 2008 and later. There was nothing like that out there in the world when we checked his references at the time when he was hired initially. Maybe we should have seen it coming, but it wasn't out there in the record, and I think that's something to consider.
Okay, thank you. Members? Ms. Harkey?
Hi, thank you for coming before the board. For the appellant, your law firm or S Corporation paid $49 million in 2004 to 6 LLCs that were created. What services did they provide that were worth over $49 million in a period of 6 months?
As I understand the structure and the way it was set up, was they took functional areas within the firm. The accounting function was one of the LLCs. The human resources was another LLC. The investigative department was one. I think the facilities department that took care of the building. And there were people employed by the LLCs that worked in those areas. And those were all of the different functions, as well as my management of the litigation and things of that nature.
Okay, didn't your firm already have personnel or HR department, accounting department, facilities management?
We did, and the recommendation from Mr. Garza was to break those functions out into separate LLCs rather than keeping them working for the firm.
Right. How many employees did each of the LLCs have?
I don't recall.
Don't recall.
That was...
Okay, I appreciate that you were trying to save some money. I just think that whenever it's $49 million in 6 months, that might appear too good to be true, and maybe should have been questioned. And I wonder why you didn't.
Well, I thought I did. It was all part of an estate plan, a reorganization plan for the firm, and there were some currency-linked deposits that were part of the plan too. It was a total
Right.
plan that was put together and provided. So I did ask, and I did ask the CPA to look at it. I asked my own CPA to look at it, and then later I asked another tax attorney to give me an opinion on it. So
I have here that Mr. Petrosilli's letter did not, though, address the deduction. He wrote a 41-page opinion, but he did not address the deductions.
I don't recall if he addressed the deductions specifically. I know I talked with him on several occasions to make sure he was comfortable with the overall transaction. I'm pretty sure I didn't ask him about individual deductions as you went through it. It was the overall plan.
Okay, thank you.
Mr. Renner.
Yeah, I'm struggling with something that seems to be too good to be true and ought to be questioned a lot more aggressively. And I tell you, at times, I do at times disagree with the Franchise Tax Board in terms of their assumptions in regards to, at times, the ability and the qualification of an individual to be able to, based upon their education or their employment, to judge, make a financial decision or how their taxes were done. However, I'm a bit skeptical in regards to a couple of issues of this transaction, and why it wasn't that you were more aggressive in regards to questioning what took place. The FTB mentioned that there was a relationship between Garza and Petrocelli. Were you aware of that?
I believe I asked my CFO to find someone to give another opinion.
Your CFO went to Garza?
I guess he went to Garza.
And you didn't, and so you were never, okay, again, so you were never informed that the person who was giving you a second opinion had a relationship with the person who was doing your tax planning?
I don't believe so.
Okay, thank you.
Okay, any other questions? Ms. Stowers.
To the Franchise Tax Board, just for kind of clarification, you kind of summarize a regulation regarding a taxpayer's education and business experience, but I'm having a hard time finding the regulation. Would you please cite the actual regulation, please?
It is 1.6664.
1.6664-4.
Okay, great, thank you. And that's where it says that their education,
Correct.
taxpayers' education, sophistication, business experience will be relevant in determining whether a taxpayer reliance on the tax advice was reasonable and made in good faith. Okay, to the appellant, I think Mr. Runner kind of addressed some of my concerns, but you said something that caught my attention. You said you did not ask about, you don't believe you asked about the deductions that were being claimed?
I don't think I went to that level of saying, is the rent expense appropriate? Is the car expense appropriate? Are the employee expenses appropriate in going through the deductibility?
Were you aware that it was going to be $49 million of deductions?
I knew it was going to be a lot, and that was why it was being broken into 6 different corporations.
Okay, all right. Thank you, sir.
Mr. Hort.
Question of the department. The 6 different LLCs that provided the service, have you looked at those?
We did look at those. A question that your board had raised to the appellant regarding employees of the LLCs. Our auditors looked at the LLCs, and the only expenses that were posted by the LLCs were primarily payments made to the appellant for that $180,000 service. The LLCs were registered by the appellant and were maintained in control by the appellant in spite of later asserted transactions. The appellant continued to make payment of annual tax and annual fees for a period of 2 or 3 more years beyond our tax year. My response to your question?
Yes. Question of the appellant. At the time of the transaction, and this question goes to the base, whether or not the deduction had a base for taking the deduction, even at that time. At the time of the deduction, what was the basis for claiming the expense as well as shifting the income around? I mean, since there appears to be, based on the department's assertion, that it was baseless.
As far as I know, the money actually went to those various corporations.
No, I believe that to be the case. The service, did the service actually take place?
It did, to the extent that we continued to function.
Okay. Move to deny the appeal.
Second.
Okay, there was a motion by Mr. Horton, seconded by Ms. Stowers, to sustain the FTB, or essentially deny the appeal. Do I hear any objections? Seeing no objections, motion carries. Thank you very much for coming.
Thank you.
Thank you. Okay, Ms. Richmond, last FTB case this morning.
Our last case this morning is B6, John R. Wrage and Kristina Wrage. Please come forward.
Are we waiting for?
No, I can go.
Okay. Thank you, Mr. Thompson. Will you please introduce the issues in this case?
Yes. Two issues in this appeal. Whether appellants have shown that the distribution they received during 2006 from their wholly owned California S Corporation constitutes a bona fide loan rather than a shareholder distribution. And second, whether appellants have shown the respondent made improper adjustments to appellant's 2007 and 2008 returns.
Okay. To the appellants, welcome. Please introduce yourself for the records, and then you will have 10 minutes on your presentation, and then 5 minutes on rebuttal.
Thank you, Chairwoman Ma and members of the board. My name is Larry Klumak. I am a CPA representing the taxpayer, John Wrage, sitting to my left. And as the Franchise Tax Board pointed out, are the distributions that were made from the corporation, from an S corporation, considered loans and or advances, or are they considered distributions in excess of basis? Some of the distributions are documented loans and others are not. The Franchise Tax Board would have you believe that the distributions were conveniently reclassified as loans and are in fact distributions in excess of basis. The Franchise Tax Board is relying on the fact that a year-end journal entry was used to correct a posting entry erroneously made by the taxpayer. The taxpayer utilizes QuickBooks to maintain its accounting records. Anyone who uses QuickBooks would know that any entry can be corrected without having to use a journal entry to reclassify the transaction. As a CPA, it is not my duty to change the posting made by the taxpayer, but it is my duty to adjust the books and records to reflect the reality of the transaction. The adjustment is made by the use of a journal entry. Chairwoman Ma is a CPA and can vouch for that methodology. It is the Franchise Tax Board position that the journal entry is what nullifies the intent of the transaction. Or should the Franchise Tax Board examine the documentation presented with the document which documents the essence of the transaction? There are board minutes, a note, and a journal entry properly classifying the intent of the transaction. The FTB argues that all the documentation is self-serving because of the nature of the fact that we have a wholly owned corporation by a single shareholder. Does that mean that no corporation wholly owned by a single shareholder is ever able to loan money to that shareholder? The FTB further argues that there was no repayment and there was no interest ever paid by the taxpayer. With respect to the repayment, there was in fact a repayment made in 2010, albeit an adjustment to the basis and a recognition of income. With respect to the interest not being paid, given that this is an S corporation, the effect would have been income at the corporation level being passed through to the shareholder and a deduction on the shareholder's tax return, effectively giving a zero effect on the taxpayer's tax return. And an entry for that was not recorded on the tax return or the books of the corporation. The next point I want to point out is that if the FTB's position is upheld, the taxpayer is being taxed twice on the same income. Before I proceed to illustrate what I mean by being double taxed, let me emphasize that the FTB has no disagreement with the corporation's reported taxable income on any of the years examined. I presented this morning a schedule that you should have in your possession. And if you would take a look at it, I've provided the top half of the schedule, which reflects the income or loss generated by the corporation for the years 2006 through 2008 and 2010. It also reflects the tax paid by the appellant on each of the years. The second half of the schedule reflects the proposed taxable income to be reported by the appellant. You will note that the proposed additional income for 2006 through 2008 is in fact the income that was reported by the appellant in 2010. And the loans and/or advances were in fact repaid by recognizing the income. The difference between the top portion and the bottom portion is the duplicate income being recognized and the double tax that is being paid by the taxpayer. I will now ask Mr. Wrage to add some additional comments.
Okay, Mr. Wrage.
Thank you for the opportunity to address you all. I'm sorry, I'm a little nervous. This has been a long process. In 2005, I concluded a 2 or 3 year business plan and made a lot of money for a pretty young guy. I paid a lot of taxes, and then I rolled into 2006 with the plan of executing that same business plan. So between 2006 and 2009, I developed and brought to market about $24 million worth of new real estate. That product ultimately delivered in March of 2009, which, with the exception of October of 1929, may have been the worst delivery date possible for new construction. I had borrowed money from my S Corp to put into these development deals. We executed the plan, we built the product, and when we delivered it, we were out off a diving board and no place to turn around. I lost pretty much everything. It's a miracle that my marriage stayed together. When 2010 came around and one of the tenants in one of my clients' buildings happened to be a bank that was involved in it, they came to me and said, "You have to get this loan off our books. We don't care what you sell the property for, but close it out. We need it off by year end." So I sold the last asset that Wrage Inc. had in 2010. I got zero cash out of it, and Larry had the bad job of letting me know that I had to recognize over $1 million worth of income on a transaction that I didn't get. or on a transaction because it was essentially wiping out my loans that I had taken from the S Corp prior. I can't explain the details of the tax code because I don't understand every bit of it, but I borrowed $1.3 million from my company through by hook and by crook to build other projects. I lost that money, and in 2010 I recognized it as income. And I know there's more to it. The documents should have been better, everything should have been better, and I ought to have somebody else doing my books other than me, or one of the helpers in my office clicking stuff in and then once a year sending it to Larry. But I shouldn't have to pay double tax as a result of that. So I thank you for your time. I hope I can address any comments you might have.
Okay. Questions?
FTV.
Oh, I'm sorry. I'm sorry. FTV, sorry.
Thank you.
I thought there was like.
Good morning, Chairwoman Ma and members of the board. My name is Todd Watkins, and I'm here with my co-counsel, Michael Cornez, to represent the Franchise Tax Board in this appeal. The notices of proposed deficiency in this appeal include 3 taxable years, 2006, 2007, and 2008. With respect to the 2006 taxable year, the primary issue concerns the withdrawal by appellant Mr. Wrage of $800,000 from his wholly owned S corporation. Appellant and his corporation treated the withdrawal as a loan from the corporation to him in his capacity as shareholder. After an audit and as affirmed at protest, respondent determined that the $800,000 transfer of funds was in substance a distribution with respect to appellant's stock. Treatment as a distribution resulted in taxable gain of over $720,000 because the distribution exceeded appellant's basis in his stock by that amount. The basis in appellant's stock at the beginning of 2006 does not appear to be at issue in this appeal. All of the S Corporation's losses and deductions were also disallowed from passing through to appellant's return for 2006 because appellant's stock basis was reduced to 0 by the additional distribution. Whether or not a transfer of money is a bona fide loan depends on whether both the borrower and the lender intended at the time of the transfer that the money would be unconditionally repaid. To make this determination, courts and your board examine a number of well-established objective factors. These factors have been established by federal appellate courts, including the Ninth Circuit and by the tax court, and have been applied in published decisions by your board. Some factors may be more important than others in a given case. An important factor is the relationship between the lender and borrower and whether they are independent entities. As courts and your board have stated many times, withdrawals by a shareholder from a wholly owned and controlled corporation must be closely examined because they are easily manipulated to avoid taxable income. In such cases, the burden is squarely on the shareholder to prove through the objective factors that the withdrawal was in substance a loan. In this case, appellant effectively stood on both sides of the transaction as both borrower and lender. Since he and the corporation were not two truly independent entities, the analysis must focus on whether a reasonable independent lender in the corporation's position would have made a loan of $800,000 to appellant on the terms that were specified in the promissory note that appellant created and how a true lender would have behaved. An examination of the factors supports that the corporation would simply not have made a loan on the terms that appellant created. First, and most importantly, the repayment of the purported loan was not secured by any pledge of property as collateral by appellant. This is despite the fact that the $800,000 represented 1/3 of the corporation's assets. Second, the promissory note had a 10-year term that required only a single payment at the end of those 10 years. The loan terms did not call for any repayment of principal or interest during the 10 years. Based on the interest rate stated in the note of 5%, the amount of interest to be accrued over 10 years was $503,000, bringing the total due at maturity to over $1.3 million. A truly independent lender would not loan $800,000 plus over $500,000 in interest to another person on a completely unsecured basis on terms that required no repayment of principal interest for 10 years. Third, appellant never in fact made any repayments, but apparently decided at the end of 2010, 6 years before the note's maturity date not to repay the $800,000 purported loan. In other words, the parties did not treat the withdrawal as a bona fide loan. Fourth, the corporation lender made no attempt to enforce appellant's repayment obligation. Appellant caused the corporation to forgive the purported debt. In other words, the parties did not treat the withdrawal consistent with its form. The facts surrounding the timing of the cancellation of the purported loan further support this conclusion. The cancellation of the debt in 2010 resulted in a deemed distribution of the amount of the principal and accrued interest. But in 2010, this did not cause any negative tax consequences such as taxable gain on the distribution, because the corporation had a large amount of capital gain and income when the bank foreclosed upon the corporation's sole real estate asset, which boosted appellant's stock basis. Also, appellant did not treat the withdrawal consistent with a bona fide loan because he did not report the bona fide loan as an asset on the balance sheet of the corporation for purposes of computing the amount by which the corporation was insolvent, and as a result excluded nearly $350,000 in cancellation of debt income in 2010 from the foreclosure that would have passed through to appellant on his individual return. Fifth, appellant did not respect the withdrawals as a loan because appellant did not cause the corporation to take the accrued interest into income annually as required by the interest accounting rules applicable to the note. Thus, appellant did not report the accrued interest of over $40,000 per year as a flow-through income item that the corporation, from the corporation, which resulted in significantly less tax for appellants in 2007 and 2008. Appellant has stated that here and on brief that he would have been able to deduct this an amount for the interest expense. However, that investment interest is subject to limitation, and the appellant has provided no proof that he would have been able to deduct the interest that flowed through to him on his return, or excuse me, the interest that he paid, that he would have been treated as paying under the of accrued interest rules. Appellants have also argued in their brief that the corporation's history of distributions supports their position that the $800,000 withdrawal was a loan. As pointed out by respondent in its brief, the tax court has stated that a history of distributions is not relevant as a factor in the context of a loan to a shareholder of an S corporation, whereas a C corporation shareholder is taxed primarily on receipt of distributions taxable as dividends, which makes dividend history relevant. An S corporation shareholder is taxed primarily on the income of the S corporation on a pass-through basis. Under the facts of an S corporation with third-party debt, to the extent distribution, in fact, in the situation of a sole shareholder of a corporation, it has always been an S corporation, distribution should never be in excess of shareholder basis unless there is third-party debt, as there was in this case. Under the facts of an S corporation with third-party debt, to the extent distribution history is relevant, the relevant question is not whether the corporation reported distributions per se, but whether the shareholder properly reported taxable gain on such distributions and properly suspended flow-through losses and deductions to the extent limited by lack of stock and debt bases. However, as is clear from the 2007 and 2008 returns, the appellant did not report the taxable gain from the distributions. Even in those years, they clearly exceeded his stock bases, and he did not properly suspend S corporation items from passing through to his return. And in the preceding years, 2003 through 2005, the distributions did not exceed bases, and so were not taxable at all, and therefore are not relevant. Facts, as discussed, demonstrate that the withdrawal was in substance a taxable distribution in 2006 and not a bona fide loan. For this reason, respondent respectfully requests that its actions be sustained.
Okay, thank you. Okay, so to the appellants,
So-
5 minutes on rebuttal.
The Franchise Tax Board's position is that the appellant never had any intent to repay the loan. if the Franchise Tax Board would, and they did examine the 2005 return for that purpose, the 2005 return did reflect a borrowing by the taxpayer from the corporation, and in 2005, that loan was repaid back. It was in the sum of approximately $400,000. And so the intent was always there, and to suggest that a taxpayer shareholder and his corporation is always not going to have independence in making that determination doesn't really stand the rules. As I said earlier, if every time a shareholder was to borrow money from his corporation, it would be denied because of the lack of independence, then there would never be a situation where a loan transaction could take place between a sole shareholder and his corporation. There was always intent by the shareholder and taxpayer to repay back that loan, and the economic conditions of the mid to late 2000 unfortunately created a situation where he couldn't repay back the loan in physical cash. This is a question here about basis and whether there is adequate basis to determine whether those distributions were taxable or non-taxable, but first and foremost, is there a valid loan? We contend that there is a valid loan based on the expectation of repayment, based on historical payments back of loans that were taken from the corporation. When you address the issue of basis, and the Franchise Tax Board is taking the position that we do not have basis. At the time we took the withdrawals, we did not have the basis, and we did have a loan in place. And at the time we recognized the income in 2010, we increased the basis to offset those deemed distributions that were taken earlier in 2006 through 2008.
Okay. All right. Any questions? Ms. Harkey?
I'll start, but I reserve the right to come back. Okay, I do believe, this is for the appellant, I do believe there was documentation provided. We heard that there was a note with a 10-year repayment. Is that correct?
For 2006, yes.
Okay. One of the issues that the FTB brought up is that there was no entry for accrued interest. Why was that? Why would that be?
If I may answer. Taxpayer is cash basis, corporation is cash basis. Code Section 267 disallows the interest deduction at the taxpayer level if the payment is not made. And given that both entities were cash basis, nothing was recorded on the corporate books and no deduction was taken on the individual tax return. Furthermore, as I stated earlier, the effect would have been zero effect on the individual tax return because there would have been interest income passing through and an interest deduction. Franchise Tax Board made the point that this would have been investment interest expense and possibly subject to limitations. This is not a question of investment interest expense. This is business interest expense and would have been fully deductible because everything that the taxpayer was performing in his line of business was in the development and construction, and therefore it would have been a business expense and not an investment interest expense.
Right. Okay. I understand that the bank would call the loan. Banks were calling loan or selling them off to vulture firms on a regular basis. And if your loan got sold off and didn't pay it, the acquirer would merely foreclose on the property, and then you would have a phantom gain, which it's quite was quite regularly done through this time. The borrowing the money for the development and then do I understand that you made a year-end adjustment to the books that created this loan because they were initially done, and so when you did the taxes, you made an adjustment to appropriately account?
What happened is that the bookkeeper that was assisting Mr. Wrage in putting his books together took every check that was written out to Mr. Wrage and classified it as a distribution.
Right, and then at the end of the year...
And at the end of the year, I made a journal entry reclassifying based on the discussion I had with Mr. Wrage as to what the intent of that money was.
Okay,
Now,
that is not unusual either. I want for the record to say that. That happens all the time.
Precisely.
Okay. You said that you would be double taxed. Explain that to me, because I see this here, but I'm not really following it mentally. What would have happened?
Well, if you look at the top portion of the schedule,
Right.
that is in fact the taxable income and/or loss of the corporation in the given years. And therefore, cumulatively, 2006, 7, 8, and 10, the taxpayer recognizes $1,369,000 worth of income. By making the adjustments that the Franchise Tax Board is proposing and adding those distribution to become taxable income, recasting those numbers would create taxable income of $2.6 million for the same years in question. The difference being $1,281,000 of double taxed income, because once it's being recognized as distributions in excess of basis, and once it's being recognized as phantom income as a result of the foreclosure of the property. And therefore, the same income is being taxed twice.
That makes sense. Thank you.
Mr. Runner.
Yeah, just take me, well, let me go to the Franchise Tax Board. Some of the conversation or some of the testimony that you had talked about the issue of the independence of the lack of independence, I guess, between the borrower and the corporation. I'm kind of lost on that because that happens all the time. Corporations, somebody who has who's a part of a corporation that will end up borrowing money from that corporation, and so I'm kind of at a loss as your explanation in terms of the independence and the illustration that somehow that had to be independent, like it was being done under the same criteria that a bank would use. Is that a requirement somewhere?
Well, courts have considered whether the terms of the purported loan.
So it's the terms, not the fact that the individual has a connection.
Sure. Well, the fact that the shareholder controls the corporation,
right,
makes it even more important that the terms
it's all about terms. It's about terms, not the relationship.
Well, the courts have looked at this context with great skepticism because of the potential for manipulation. And
because of bad terms?
No, because of the potential to time dividend, to time.
But wouldn't the court be looking at that because of the inadequate clarity of the terms and the benefit then to the taxpayer?
Well, in this case, the lender and the borrower are on both sides of the transaction.
Which is not unusual.
Well, usually, I don't.
Yes. It would be correct to say that it's the terms
that
you look at,
but because they're related parties, you look with more scrutiny
Right.
and
Thank
skepticism.
you. Yeah, I think that my point is that it's you look at it more with greater scrutiny because of the relationship that the borrower is on both sides of the transaction.
Correct.
And so it's up to then for clarity in regards to what that agreement is and how well that agreement is spelled out.
Correct,
Okay.
because they have the opportunity
Okay, thank you. And again, that would be my understanding, and I just felt like maybe we were being overstated in regards to the fact that there's conflict automatically because somebody's on both sides of the transaction. Let me just ask, because it seems to me what we've got here is a transaction that had an intention for what the future would be based upon what the experience of the past had been. And there's a whole group of people out there in the state of California who anticipated that things would continue the way that they were going back in 2006 and 2005, and therefore bet a lot of money and invested a lot of money based on things that they would continue. And unfortunately, they didn't. So, but any agreements that were made during that period of time, either in paying back a loan, whatnot, wasn't based upon the assumption that there was going to be the dramatic turn down that we had. It was based upon things that were going to continue the same. And so I think that's where all of a sudden it's difficult then to look at a note like that and kind of like with history now and say, well, gee, that note looks like it's too generous. It doesn't look like it's going to have this amount of interest attached to it when you pay it back. And you look at that and you say, well, wow, that's a generous terms of note. When in fact, if you were making that deal in 2005, based upon what you had experienced in regards to what you had earned in the previous years, you'd say, hey, if I can go ahead and do that, I'll be glad to pay that interest all in a lump sum back in 10 years from now, because I'm going to make a lot more money. Unfortunately, it didn't happen that way. And so I'd assume that that's indeed what the challenge was in terms of the note itself. Let me ask you about the note itself, because again, I mean, the 2006 note. Clearly, the 2006 note did indeed have a term attached to it, correct?
Yes.
It had an interest rate attached to it.
Yes.
It had a repayment schedule attached to it.
Yes.
Now, again, it may be somebody who say, oh, the repayment schedule that was in 10 years and interest, but it did indeed have those elements attached to it. So the 2006 issue seems to me pretty well structured. And again, I trying to put my kind of the lens that I'm looking through it with is kind of the business circumstances of 2005. And what people would anticipate would be the continuing of that as we would try to figure out how to invest money and experience that in some greater ways in the future. Let me ask more specifically on the 7 and 8. Because that help me understand then the 7 and 8 years, because obviously 6, we've got this clarity in regards to the relationship with a note. We have all those other issues. Tell me about 7 and 8.
7 and 8 was simply a continuation of what took place, but unfortunately no documentation was made. Did not go through the mechanics of creating a note and crossing the T's and dotting the I's that took place in 2006. But the substance of the transaction was the same as what took place in 2006, lacking the documentation, however.
Let me ask why.
I don't have an answer for that.
No, my lack of attention to the detail. The question is, what can I say now to prove those corporate loans up as bona fide? Is nobody caught us. I wasn't trying to avoid income. I recognized those loans as a distribution in 2010.
Mm-hmm.
So, I mean, the ultimate, to overuse the pun, the ultimate proof in the pudding is I did recognize. I mean, so what makes a loan? What makes a loan is repaying the loan or approving it out.
And then regardless then of whether or not it was identified at that point, your contention is, based upon some of the discussions that Member Harkey had, and in terms of clarifying in which the material that you presented, that would have indicated that then would be the piece that you distributed to us, indicating that if indeed there would be this double payment of tax, if indeed it was applied, if they were not considered as loans, you would end up with the double payment of tax. Is that correct?
That's correct.
Okay, thank you.
Okay, Ms. Stowers.
I have a couple of questions for FTB appellant and legal appeals. Let's start with appellant. Are you saying on your schedule that if FTB's position stands, there's going to be double taxation, taxation one because of the distribution, and then taxation again because the property that the $800,000 was used for was foreclosed upon? Am I getting that right?
That is absolutely correct.
Okay. In my notes, and our hearing summary indicates that the investment for the property was never made. In the supplemental brief, it states that the investment was not made. Please clarify.
Two different investments. The property on which the debt was taken out was a property owned by the corporation, and money was borrowed by the corporation and then lent to the taxpayer. Taxpayer was using those loan proceeds to invest in another project outside of the corporation on another real estate development in Las Vegas. That development never materialized because of the real estate market conditions and the deterioration of the situation, and therefore the money that was borrowed with the intent to invest in an additional project never went through.
So that's the same loan that we're disputing right now, right?
That's correct.
Okay, so it seems like it's two, maybe three different transactions. Yeah, I'm just kind of, there's multiple transactions here. But for the loan, the loans distribution that we're discussing, the $800,000, the Las Vegas property, that investment did not take place.
The Las Vegas property did not take place, did not go through.
Did not go through.
That's correct.
I had two other properties that did, and the money went into those.
That was going to be my question. Yeah. So now the $800,000 that you say is a loan was eventually used for some other property.
Right.
And this was for your property that was going to be owned by the company or property owned by you?
Property is going to be owned by the company, or by a separate LLC.
Not by the company?
No.
That you got
no, that's why the loan
from.
Came to me. I invested in another LLC to build two.
So it's a different investment outside.
Right. During this period of time, I built 8 office buildings and 2 industrial buildings.
And this is just a comment. It's what it seems to me, and I'm not asking you to respond, but it seems like you're using your one corporation and its funds to invest in other businesses, which is kind of not proper under the tax code. That's just my observation. To appeals, I kind of would like for you to give me some clarification on RSC Section 267 and whether or not that statute speaks to whether interest should be accrued on a loan.
Not sure that interest. I'm not sure that interest would be accrued on a loan, but that interest.
You want to take a second?
Yes.
Okay,
yes,
fine.
please.
Okay, go ahead, take a second. To the Franchise Tax Board. I'm looking at the appellant's schedule where they're saying that if your position is sustained, there's double taxation. I'm not sure if I follow that. It seems that if there was a distribution, as you guys are arguing, in 2006, that distribution is taxable because there's insufficient basis, and that's one transaction. And then the subsequent foreclosure by the bank and the phantom income as a separate transaction in a separate year. Could you speak to it, whether or not if we were to support you, if there's double taxation?
Well, this is the first time that appellant has submitted this schedule. This is the first point I'd like to make. So we haven't had a chance to really prepare a response in detail. However, the numbers in the second column, taxable income reported by J&K Reg, not able to, except for 2006, these appear to be, the 102,000 appears to be the sum of the disallowed deductions, that flow-through deductions, but these other items don't appear to be the combined taxable gain and suspended losses. So I don't know what this second, I don't know what it relates to. I don't know if it's not the income of the corporation that I can tell. It's not. So I'm not sure what that second numeric column means. And also, I also point out the 2009 information is left out. I can supply that because I have the information from the 2009 return. I don't think it was part of the exhibits. So that's missing, which would throw off the numbers. And also the 518 starting amount, to the extent it's even relevant, it's not the retained earnings, it's not the AAA account, it's not the stock basis. So really don't know what this schedule is representing. I can tell you that there's no double taxation. The phantom income, to the extent of the foreclosure, the relief of the liability is what you are referring to in 2010. That resulted in gain, and then to the extent above fair market value, there was cancellation of debt because he claimed insolvency. So unfortunately, he didn't take into account the $100,000 loan as an asset. He wrote that off before computing his insolvency. So that gain, the distribution was absorbed by the increased stock basis. So there was no taxation in 2010 resulting from that foreclosure. Now, another point, they've referred to 2007 and 2008 as being loans as well, and there was no bookkeeping entries as loans on the books for those. So I'm not sure what they're referring to those being loans as well. So.
On the kind of going backwards, because I want to talk about the 2005. Did you guys verify a loan was made to him, to the appellant in 2005, and concluded there was a valid loan?
It's reported on the balance sheet, and I'm not sure if we had the books and records for the financial information for 2005. However, because of the amount of gain reported by the corporation that year, he had sufficient basis to absorb that loan being treated as being distributed back to him. So in other words, because it was a $400,000 loan and there was $1,300,000 of increase in stock basis, it didn't really matter whether he paid it back and then distributed it back to him or just wrote it off and it was a deemed distribution. Economically, it's the same way. There was no gain reported in 2005 from that loan. But it just wasn't on the books going into 2006.
So did FTB audit it? So you're saying you guys did or did not audit it, or you just didn't?
There was no reason for that to audit the $400,000 loan, because there would have been no taxable gain as a result of it being disallowed as a bona fide loan.
Okay. With respect to the note, do you find this note to be a valid note that a lender borrower would have that did not have a relationship? Meaning, did this note have a scheduled fixed payment? Did this note, did they make regular payments on it?
Well, no, and that's a factor the courts look at is, not only was the repayment period 10 years, which at some point a repayment period of way in the distance becomes similar to a demand note. And demand notes are looked at very unfavorably by the courts. So, and the fact that there's a repayment schedule of one payment in 10 years is not a fixed regular repayment schedule that is looked on favorably by the courts. no payment of interest or in this case even accrual of interest reportable by the parties also is looked at very unfavorably. So it's the terms of the note. I would also argue 5% interest rate, while it's above the applicable federal rate for that year, that was below what the bank who was charging the corporation, which was 6.8% variable rate, and it was secured by the collateral. Here, the corporation did not have any security for its $800,000 loan to appellant, and yet it was charging a lower rate. So, bad business deal for the corporation in terms of an arm's length lending arrangement.
I was going to ask about the collateral, but you answered that for me. Thank you, FTB. Appeals?
As a cash basis taxpayer, under 267, unless there was interest income being charged by the entity, there has to be a matching. So unless interest would be being charged or accrued and paid, there has to be interest on both sides. So unless
Charging one and needing paying.
right, there has to be interest on both sides. So unless there was interest being accrued and then paid, there has to be interest on both sides. So unless there was interest being accrued and then paid, then there would be no interest accrual. So there has to be interest accrual and then paid.
It's cash based.
There just can't be interest accrual.
It has to actually be paid.
It has to actually be paid.
So in this particular case, there's no dispute that interest was not paid.
Correct.
And so since interest was not paid,
someone just can't accrue interest.
you just can't accrue it on so the S corporation could not accrue interest income.
Right, they just can't accrue and get the benefit of an expense.
Okay, because it was not actually paid by the borrower.
Correct.
But does that mean that?
They just can't accrue interest and get an expense. They can send a bill out, and if somebody pays it, they get an expense, and then they can get a write-off for it.
He's supporting the taxpayer here.
I think.
Because they're a cash basis taxpayer.
FTB, do you
Yeah,
want
I'm
to speak to
sorry.
that?
Yeah, I meant to speak to this before. I'm sorry that you just engaged in that whole exchange because I don't think it's relevant. The appellant here at the appeal has characterized the corporation as being on a cash basis. It was on an accrual basis, as stated on every return it filed. That means 267 is simply not relevant. That requires matching if the let's see here, where's 260? That requires matching if the
taxpayer,
I
the borrower
get
and the lender are related parties.
Yeah, if they're related
Okay, yeah,
parties.
okay, I understand now. I just had to go back. So your records for the S corporation, they're reflected. They're on accrual basis. They're accrual basis taxpayer.
Right.
So you're saying that RSC section 267 does not apply. It's out, Mr. Appellant.
I respectfully disagree with the Franchise Tax Board over here. Even if the corporation was reflecting accrual basis reporting, 267 does not allow deduction unless the payment is made and recognizes income on the other side. Both entities, because of the related parties, because the taxpayer, the individual taxpayer, is 100% shareholder and is related to his corporation because of that ownership, there has to be a matching factor here for the income to be reported on one and deducted on the other. And therefore, if it wasn't paid, it's not reportable and it's not deductible. 267 speaks very loudly about that you must have the matching factor if there is related parties, which in fact we have related parties over here.
Could I just respond once more to that?
I'm gonna, because it's just whether interest was accrued or paid is just one of the factors that we have to consider.
And let me also.
I'm sorry, I'm good. It's just one of the factors, and I understand your argument. FTB, I understand your argument, but there are, depending on which court case you're gonna rely on, 7 factors or 10 factors of whether or not there was a distribution or a loan. I'm good. Thank you, Chairwoman.
Mr. Horton.
Thank you, Madam Chair. Part of the discussion, the cash basis versus the accrual basis and so forth, from my perspective, seemed to be somewhat of a red herring, but the issue before us, from my perspective, is whether or not this was a distribution or a loan. And so the conditions and the terms of the distribution and the loan, the courts have consistently said that it should be reasonable within the market rate. The corporation and the shareholder can make whatever decisions that they want to make. If they want to make a 10-year loan, they can do so if they want. It's just the condition is that you can't cause harm, excuse me, to the corporation. The corporation can't be in a negative or worse position as a result of dealing with its shareholders, as an indication as to whether or not this is a dividend versus a loan. In this case, the evidence seems to indicate that if the corporation was to loan the funds out in any other circumstances, the terms would not be reasonable, and the interest rate would have been higher. The repayment would have occurred in a more timely basis, and the term of the loan would not have been extended to beyond a period of time, especially given the volatility during the time of the loan, the market and the actions and the transactions. So it seems the actions themselves are not consistent with what would have happened in an arm's length transaction between two independent parties. Accordingly, I would move to sustain the FTP.
I do have questions. So, can we talk about the $800,000 loan? Was that from, and maybe I've been kind of going through the fact pattern. So, was some of it from a line of credit, and some of it from the bank loan refinancing, or where did that $800,000?
Some of it was cash, and some of it was from, I had a revolving line of credit, or I shouldn't say I. Wrage Inc. had a revolving line of credit that the primary asset of the company was a 30,000-foot industrial building that had a tenant in it.
So it's collateral,
So it was
collateralized by that.
And I had a floating line of credit with a local bank that we were friendly with, or I was friendly with, and so some of the money was out of cash, and some of it came from that line of credit.
So the line of credit, who was the personal guarantor, or?
I was.
You were, okay. So explain to me what happened in 2010, because I'm not really sure what happened.
So as time went on, so I lost my tenant in 2009. So between 2009, the beginning of 2009, and the end of 2010, my building was vacant. I made property tax payments and interest payments for a period of time until I ran out of money.
Okay.
And for about 6 months, I didn't make any payments to the bank. Mission Valley Bank is a small bank in the San Fernando and Santa Cruz valleys. Okay. They came and said, "Hey, we need to get rid of your loans. We need your stuff off the books." By that time, the corporation had debt of, I can't recall the numbers, but it was
from the loan.
Yes.
Or loans.
For loans
and
with that bank for $2.5 million maybe, or $3 million, something like that. The bank needed it off the books, so I did a fire sale. So it didn't go all the way through the foreclosure process. It was a kind of a friendly foreclosure. Sold it to somebody, and the proceeds were less than the loan amount. They were also greater than my basis, so that created a taxable event at that time.
Okay, so then what did you report, or to the CPA, what did you report on 2010's tax returns?
The gain that was being reported was from the proceeds, or the sales amount minus the basis of the particular property, which generated over $1.3 million in gains from that transaction. With other expenses, the net income that was reportable by the corporation was $1,211,000, which in turn was reported by the taxpayer on his personal tax return.
I'm sorry, so, one more time. So 2010, you reported the gain less the basis.
As a result of the foreclosure, the sales proceeds equal to the amount of debt being relieved and the cash being received against the basis of the property that was owned by the corporation, resulting in a gain of in excess of $1.3 million. Other expenses in the corporation netted against that gain yielded income reportable by the corporation and passed through to Mr. Wrage of $1,211,000. And he paid tax on $1,211,000 in 2010 without receiving any cash.
So as part of the, I'm trying to figure out, so he owed the bank money.
Correct.
He owed the bank $2.5 million, let's say. He sold the building for, how much did you sell the building for?
Whatever the sale.
$3 million.
You sold the.
Well, then the debt exceeded $3 million. Yeah.
I'm sorry, it was $90 a foot, so I can do the math. It was 2.7 million.
Okay, how much was the debt? 2.7.
I don't. I'm sorry.
About. Okay, just get.
It was
yeah.
it was in excess. It was in excess of 2.7. The building was upside down as a result of accrued interest that was charged by the bank, and as a result of the outstanding principal.
I got that, but how much was the asset sold for? Like the building.
$2.7 million.
2.7, and then the debt was 2.7 from the bank.
It was more than that.
More than that. So that, okay. And then as part of the basis, what happened to the $800,000? So you included the $800,000 loan as part of the basis, or what did you do with that?
No. The $800,000 becomes a deemed distribution as a result of having basis in the S corporation, resulting from the recognition of the $1,211,000. The corporation has no assets at that point. Corporation generates taxable income of $1,211,000. Because Mr. Wrage recognizes $1,211,000, he creates basis in the S corporation at the end of 2010. The $800,000 is a deemed, and all the other loans are deemed distributions against the $1,211,000 of basis as created, and brings down his basis effectively down back to zero.
Okay, so this is what I'm having. I'm not up to date with my loan to basis, to converting the loan to a distribution. Who is like an expert on this? Because normally, right, you take a loan, and then if he had sold his property, he would have paid back the loan plus the interest, and everything would have been, off the books, right? But due to this sale, forced sale, so to speak, by the bank, now they've reconverted the loan to a distribution in 2010 to reduce the basis.
Two separate transactions. One is recognition of gain through the foreclosure or forced sale, producing income, which increases the shareholder's basis.
Right, I got that.
Okay, then they decide we're not going to, he decides I'm defaulting on the debt, not paying it back, and I'm going to cause the corporation to cancel my debt. That causes under case law, but then also the regulation that's been on the IRS in the regulations for 40 years, 301-1M, a cancellation of a shareholder debt is a deemed distribution. So even though no cash, it's, 'cause economically, it's just, I got my cash earlier, I'm not paying it back. This is now I'm recognizing that income as
So they did it right on the tax return?
only if it was a loan originally in 2006. And that's the dispute, because we
That's
say.
your dispute.
So, okay, so 2010, if it was properly deemed a loan by them on the minutes of the meeting, right? It was in the minutes, there was a loan dated April 13, 2006, that stated the amount, 10-year.
There was a check.
five-
The check has no description on it, and it was credited to or debited to the draw account later at the end of the year pursuant to an adjusting entry in 2006. It was converted to a loan on the books, and also in the corporate minutes, all prior actions of the year were authorized in retrospect in the Board of Directors minutes authorizing that loan. So
it was in the minutes saying it was a loan.
it was the minutes in the last
Right.
year
And
adjusting.
then the
entry.
accountant adjusted it at the end of the year, which is
Correct.
kind of what happens, right? People keep their books on Quicken or QuickBook, and the accountant comes back and he made the adjusting entry, so it wasn't like they went back and redid all of the transactions in QuickBook
Well, except that
to say it was
the
like a
check
loan,
itself-
loan.
The check itself for $700,000, the $800,000 was comprised of a $700,000 check and a $100,000 line of credit draw. The check did not have a description saying loan to Mr. Wrage. It was just a check.
I get it.
So in the
But
promissory
your
note.
bookkeeper wrote the check, right? Who wrote the $700,000 check?
Probably me. Okay. I mean, I don't have a book. You're looking at Rage Inc. So
Okay.
This is all there is.
Okay.
Let me go back to your how this question got started. In 2010, the corporation recognized $1.2 million of capital gain from the foreclosure.
Right.
That shows up on the S corporation's tax return. So whether
Okay.
his basis was $0 or $25 million, he had $1.2 million of income that he reported on his personal income tax return.
And paid taxes on it.
And paid taxes on.
Okay.
When he then reports a deemed distribution of $800,000 by converting the loan, by discharging the loan, he had $1.2 million of basis, reduces his basis to $400,000. He doesn't pay any tax on that $800,000 deemed distribution. He treated it as a loan, so his basis would be $400,000. We say no, it was really a deemed distribution back in 2006. So your basis is not $400,000 in your S corp as of the end of 2010. Your basis is now $1.2 million. But he doesn't pay double tax.
No, he doesn't pay double tax, but he reported the income.
He didn't
right?
report
the gain. Well, on his 2010, he reported the gain
Right.
from the sale of the property, and then he reduced his basis by the $800,000,
Right.
which is what would have happened
Either way.
correctly had it been a loan.
Right.
Then he would have reported it correctly.
But timing is everything
I understand.
when you have basis.
I
because in
understand
2006
timing is
it was-
everything. I'm just
Okay.
trying to establish whether they reported everything according to what they have purported correctly, meaning they reported the loan, they believed it was a loan. When they sold the property, they reported the gain properly. And if it was a loan, like they contended, they reduced their basis by that amount, which is what they should have been doing. I just want to make sure that they did everything consistently in their reporting based on what their contention is, that $800,000 is a loan. Did they report everything correctly in their reporting from 2006 to 2010 when they filed their S corporation tax return as well as his personal tax
I
return?
would no in two respects. First, they took pass-through deductions from the S corporation in excess about $30,000 that should have been suspended in 2006, even under their own treatment of the withdrawal as a loan. So they inconsistently treated the.
And what was this? I don't. What
30
was this $30,000 in what?
Deductions at the S corporation
What
level.
kind of deductions?
Ordinary business laws, rental laws, contributions, other expense items. So I have these specific schedules, but that $30,000, they consistently took pass-through law. In 2007 and 2008, they didn't report taxable gain from distributions in those years either, even though their basis was reduced to zero. So, and they also didn't. They also took all.
Why would they do that in 2006 and 2007 when it's not related to a loan or this loan? I mean, we're talking about this loan.
Okay. Yes, those were separate, and those are separate issues. However, okay, so the disallowed losses in 2006 of $30,000 they took, despite that the distribution that they did report plus their total deductions exceeded their basis. So they had suspended losses. They took them anyway.
And did you guys audit them, or
yeah, that's
federal
part
government
of, that's part
audit?
of,
Okay, and so you guys disallowed it.
Yes, but it was part of the total that we disallowed on treating it as a distribution in 2006. The other important thing, and we keep coming back to it, is the failure to report the accrued interest that passed through. And I can go back to the statute and show why 267 is not applicable. It only applies when you have a cash basis lender and an accrual borrower. The taxpayer, the borrower here is a cash basis, and the corporation is accrual. So 267 simply does not apply. The general rule is that the taxpayers take interest into account under their ordinary method of accounting in computing their taxable income. For the corporation, that was accrual.
I hear you. You said the corporation was a cash basis.
That's my recollection.
Do we have a copy of the tax returns?
But they're in the exhibits every year's.
Okay, I only have modified.
Okay. Exhibit L, page 2, which is the 2010 S Corporation return. They've checked box Schedule Q, box L as accrual basis.
Same for 2006 as well.
Okay, so appeals. You should have it.
Yes, I'm looking.
Exhibit
I
L.
believe them. If it's
No,
accrual, it's accrual.
isn't there a box that you check? Is this corporation
just
S corp
referenced it.
or a cash basis? Right? Did you prepare the tax returns?
I did.
Okay.
I did.
So, if you check the box that it's accrual, it's accrual.
Absolutely.
Okay. So, that's what I think we were getting at. Did you accrue the 5% interest? I'm not so concerned, 5%, 6.6. You will establish some sort of reasonable interest, right? It wasn't 0. 5% I don't think is off the mark, but
Well, it's
would
also
you have-
AFR, which is it's also AFR,
Right.
which is an acceptable interest
exactly.
rate.
I don't have a problem with 5%, but should you have accrued the interest at the S corp level if the S corp was, an accrual-based taxpayer?
And I'm taking the position that 267 would not allow you to do that because of the relationship between the shareholder and the corporation. Related party rules would not allow you to do that. That's my reading of 267.
Okay, so, but when you, so let's say, they didn't accrue the interest for those 3 years. At the end, in 2010, you should have probably accrued the interest on the $800,000, right?
And the effect would have been 0.
I get it, but how did they report it on the tax return?
But
Just the
all-
800,000,
all-
or they would have?
All you would have reported, let's assume we had interest of $50,000.
Right.
$50,000 income would have been reported on the corporation, passed through to the taxpayer, and he would report the $50,000 income. And at the same time, he would have a $50,000 deduction for making the payment of the $50,000, netting to a 0 effect on the individual tax return. Given that this is a pass-through entity, it would come down to 0. It would have no additional income tax realized from accruing and paying.
No, I get it, but when you decrease the basis in 2010 from 800,000, it should have been $850,000
But
with
it
the
would have
interest.
been, but the basis would have been increased because of recognizing the interest income.
Okay, so what do you guys say to that?
Okay. It is true that it's true that the interest income would also increase basis. However, that does not. the interest floats through and is reportable on the individual return as interest income. It's a flow-through item. They're saying that they would automatically have a deduction. What I'm saying is what we're saying is the fact that they have to accrue the interest means that it's to the extent it is deductible by the taxpayer as borrower, he would be able to deduct it. But the general rule is under 163H, personal interest that is personal interest is generally not deductible. So if it has to be something other than personal interest. So it would have to be, say, investment interest. Then they would be limited by their investment income. They haven't shown that they had any investment income for any of these years to which it would be deductible. And especially in 2010, after all his property is gone, I'm assuming there would have been no investment income. And furthermore, the amount of interest we're talking about is $206,000, which was reported in the amount of the increased distribution. So they reported it in the loan balance account.
They did.
As a debit, increasing the amount of the loan balance. They reported it in the distribution. They never took it into account as income. So, and because of the gain increased the stock basis, it wasn't taxable as gain. The proper way to report it was as income, an income flow-through item. And they didn't do that in any year, including 2010. So $206,000 over that period was not reported into income, and there's no evidence that they would have had a deduction in that same amount.
Okay. I may come back. Ms. Harkey.
Okay. What I think we're relying on 267 because it was closely related corporation. And you keep going back, FTB keeps going back to something else. Now, what the bank showed as debt forgiveness would have included the interest. But that doesn't have any relation to him except for his write-off if he has to pay taxes on it. Is that not correct?
That is correct. And furthermore, just to go back and respond to what he is saying, Franchise Tax Board is assuming that interest is going to be investment interest and subject to a limitation, or personal interest and subject to a limitation.
Right, they said
clearly the borrowing was for business purposes, and the interest deduction would have been a business interest expense and not subject to any limitation.
Right,
Furthermore, he's talking about not having investment income. The mere fact that there's $1,211,000 of gain recognized in 2010 is in fact investment income and would have been characterized as such, and would have, even if the interest was considered as investment interest expense, would have been deductible under that theory.
Thank you.
I want to go back to 7 and 8 real quick. How did you handle when those books were given to you at the end of the year? How did you handle that?
7 and 8 was left as is. No adjustments were made. There were advances. They were not reflected into the loan account.
Okay.
So there were distributions.
They were reflected as distributions, yes.
Okay.
I don't know.
Stars?
Are we done with questions?
Well, no, I got it. No, just
Word.
question of the department.
We'll see what happens.
Question of the department. As the law requires us to look at the intent at the time of the transaction, the subsequent cancellation of the debt 4 years subsequent to 2010, how would that affect the decision in 2006? And yeah, that's it.
If I understand you correctly, you're asking how is it relevant, the treatment of the loan in 2010?
Yes.
Well, it establishes the conduct of the parties with regard to this purported loan. If it's treated as a truly unconditionally enforceable obligation, then the borrower wouldn't simply decide to not pay it. The corporation continued into business. We have the 2011 return. It was continued to do business. There's no reason that has been presented for why the money was not actually paid back into the corporation in 2010, rather than simply canceled. So it shows a inconsistency with the proposition that there was intent at the time of this initial transaction in 2006.
Can you cite any authorities to support your position?
I think, well, that
to catch you off.
Yeah, well, that was briefed.
There
That issue was briefed, and
It's the only reason I asked.
Okay.
In your paperwork.
Well, yes, the lack of repayment is one of the factors, and it's one of the most important factors. So, in the sense that it was not repaid but simply written off, that's strong evidence against there being a bona fide loan. Furthermore, as I think I pointed out previously, they didn't take the loan, they didn't treat it consistently for reporting cancellation of debt income. They had $349,000 of cancellation in debt from the value of the loan amount on the property being above the fair market value. So when it was sold, there was gain up to the fair market value under the realization of income rules, and there was cancellation of debt in the amount from the fair market value up to the loan balance. That's ordinary income, not gain. And to exclude that income, you have to come within one of the one of the exclusion exemptions, bankruptcy, insolvency, a couple of others under Section 108 of the Internal Revenue Code. And so they claimed insolvent.
I thought I heard the appellant did claim the insolvency exception.
Did, but he didn't report the loan on the balance sheet as an asset. If the loan had been treated as an asset instead of written off, they wouldn't have been insolvent, and that's $349,000, which they claimed to be non-taxable income, would have flowed through to them as taxable $349,000 of income onto their individual return. And again, they didn't treat it consistent. They took it, advantage.
So, sorry, can I just add? So you're saying are you still in business, Mr. Wrage?
I'm sorry. I mean, there was nothing in my life in 2010 that was for my advantage, and I don't really. If everything goes right, by 2020, I'm going to be out of the storm.
Right. But okay, but I'm saying you're still in business.
Yes.
Okay. So, to the franchise tax law, you're saying that if they still had the loan on the books, and it's 2016 now, 10 years later, and they hadn't paid it back still, then what?
Well, it was due April 13th of 2016, paid back in full, so with interest, accrued interest. So they would have owed, I think the total interest was $500,000. I think I mentioned it in my opening statement. Total accrued interest on the schedule was computed to be over $500,000. So they would have owed $1.3 million in April 13th of this year, and they did.
So can we just talk about the insolvency in 2010 again? So
can I respond to one thing
Sure.
that they keep missing?
Yes.
Had the cash been available from this transaction, a distribution would have been made to the shareholder, which would have reduced basis, and they had basis to take that distribution, and they would have in turn paid back the loan. It's a circular effect that whether you receive the cash and turn around and pay it back, or whether you consider the loan as a deemed distribution, it has the same effect on the balance sheet of the corporation. And that's what seems to be missing in the explanation, is that what took place and what got recorded on the books, in effect, whether there was an exchange of cash or not, would have created the same effect on the corporate books. As far as reporting the income recognized from the sale, whatever income was recorded was based on the sales price minus any forgiveness of debt, which was an adjustment to the basis in the property. And there was insolvency, and to the extent of the insolvency under Section 108, there's no income to be reported by the corporation. And those factors were taken into account in calculating the amount of the insolvency, the amount of reportable gain, the amount of the basis on the property being foreclosed on, and proceeds received from the sale, which was basically cancellation of debt by the bank. And so it is our position that the insolvency calculations were calculated appropriately based on the assets and the liabilities of the corporation. We did not exclude reportable income by not reporting an asset of the corporation.
Mr. Runner.
I'm gonna make a motion for the taxpayer on his claims.
I'll second.
And let me just say, I think the issue that we've got here is that, to me, I mean, the clarity here that in terms of, for me, that this is a loan, not a distribution. I think the thing that makes this very complicated is that it was in the midst of an unprecedented real estate fall, which again, it would be very clear if everything was done correctly, and I mean, not done correctly, but things would have sustained, loans would have been made, loans would have been paid back, all that would have been done in a normal basis. Unfortunately, I think what we've got is just this dramatic economic turmoil that took place, which then ends up making this a much harder process to follow. The assumptions that what should have been done could have been done. How would this have been done if these economic conditions were different? The fact is they weren't. So again, I'm going to fall back on the note itself, on the fact that it was done in good intention, based upon doing business going forward.
Objection.
And I'm going to say I'm going to vote with the taxpayer. I just think that that was the intention. I think they've documented it. You know, it's been consistent. They reported it all consistent with how they should have reported had it been a loan. So, you know, sometimes it's not, you know, to the best of, you know, documents and signatures and interest rates and reporting, but I do think that it was the intent of the taxpayer, and the CPA was there. He's been reporting consistently. He made the adjustments. He, you know, reported properly at the end based on the intention that it was a loan. So, Ms. Stowers.
Yes. I'm going to object to that motion. Based on my review of the facts and evidence, the evidence does not support a debtor-credit relationship between the appellant and his S corporation. The transaction was initially recorded as equity withdrawals. No interest was accrued or paid, no security for the loan. The note was signed April 13th, 06, but the funds were advanced on two separate dates, one date April 13th and again on September 8th. The debt was canceled in 2010 after the audit started, and they reclassified the asserted loans to a distribution, which resulted in a sufficient tax savings for them because at that time in 2010, they had sufficient basis.
Madam Chair, unfortunately, I'm going to have to object as well. The effect of the various different transactions and the hypotheticals that have been put forth are just not consistent with the facts. The facts indicate that the actions and the characterizations of the transactions are such that they're not consistent with the law as it relates to what would be established as a loan between two parties that are not independent of each other, without restating the discrepancies as articulated by Member Stowar. That's just sort of what this is rather simple from my perspective, and the conditions just aren't there to establish that this was a bona fide loan as it relates to the law. I get the discussions. I mean, I get the intent, the hypotheticals, and so forth, but they're not consistent with what the facts are in this case and how the transactions were actually recorded, how the transactions were subsequently characterized, and the mere fact that the taxpayer anticipates is still in business. Quite frankly, they did not necessarily even have to cancel the loan, could have carried the loans forward, but there was a benefit in the cancellation, so I guess that's sufficient.
Okay, so there's a motion and a second. Motion by Mr. Runner, second by Ms. Herkey. Ms. Richmond, please take the roll.
Chairwoman Ma,
This is to go with the taxpayer.
Right.
Aye.
Ms. Harkey,
Aye.
Mr. Horton,
No.
Mr. Renner,
Aye.
Ms. Dowers.
No.
Motion carries.
Good luck.
Thank you, members.
Any other cases this morning?
No.
Okay.
We
Can
need
take-
to ask for a clarification because there was
Sure.
3 different tax years and the 800,000 only related to 2006, not 2007 and 8.
Primarily,
The motion was for the taxpayer?
All of them,
Grant-
all
to
years?
grant-
Yes.
Grant the appeal.
Okay,
That concludes our hearings.
so
All years?
do we want to take a lunch break?
Yeah, I think so.
Okay. All right, let's take a lunch break, and then we'll come back at 1:30. Okay, thanks. Okay, we are back. State Board of Equalization, Ms. Richmond, please call the first item, or?
Our first item for this afternoon is Surrey Investments, and we're still waiting for that taxpayer to sign in. So we will start with item G, the tax program non-appearance matters consent.
Okay, that's a different binder.
Okay.
These items may be taken in one vote.
G.
You guys should go electronic.
Okay. We're going G1, right?
G1.
Okay, here we go.
Make the motion to adopt staff recommendation.
Second. Non-appearance, right?
Okay.
Madam Chair?
Yeah, G1, legal matters, non-appearance matters. Okay, there's a motion by Ms. Harkey, second by Mr. Horton to adopt staff recommendation on items G1.1 to G1.4. Without objection, motion carries. Next item, Ms. Richmond?
Our next item is G2, franchise and income tax matters. These items may be adopted in one vote.
Move staff recommendation.
Second.
Okay, Ms. Harkey moves staff recommendation, seconded by Mr. Runner on items G2.1 to G2.20. Without objection, motion carries. Ms. Richmond, next item.
Our next item is G10, legal appeals matters, legal appeals property tax matters. This is a constitutional function, therefore the deputy controller may not participate in these matters under Government Code Section 7.9.
Moves to adopt staff recommendation.
Second.
Okay, Mr. Horton moves, Ms. Harkey seconds, noting non-participation by members Stowers to adopt staff recommendation on items G10.1 to G10.2. Without objection, motion carries. Ms. Richmond, next item.
Our next item is item H, tax program non-appearance matters adjudicatory. There is only one sub-item.
Move to adopt staff recommendation.
Second.
Okay, Ms. Harkey moves to, I think this is to make the decision in this case as some, decision?
This was the.
It's been decided, this is just to adopt the Section 40 decision for publication.
Okay, so to adopt the Section 40 for,
publication pursuant to Section 40.
okay, for publication, subject to Section 40, motion by Ms. Harkey, seconded by Mr. Runner. Without objection, motion carries. Next item.
Our next item is H2, franchise and income tax matters. There's only one sub-item.
Move adoption, staff recommendation.
Second.
Okay, Mr. Runner moves, Ms. Harkey seconds to grant the petition. No, hold on. Is this a petition for rehearing, H2?
Yes.
Okay, to grant the petition for rehearing without objection.
Staff recommendation is to deny the petition for hearing.
Okay, sorry, my script is a little bit off right now. Okay, so to deny the petition for rehearing, okay. Deny staff recommendation on the rehearing, moved by Mr. Runner, seconded by Ms. Harkey without, Mr.
I'm sorry, just to interject, the staff recommendation is to deny the petition.
To deny the petition.
Correct.
Yes.
Moving to
So we're moving to deny the
We're moving to adopt
staff recommendation to
Which is to
deny
deny
the
the-
rehearing.
Correct.
Okay. Moved by Mr. Runner, seconded by Ms. Harkey, without objection, motion carries. Next item.
Our next item is I, tax program non-appearance matters. Item I2, offer and compromise recommendations.
Move to adopt staff recommendation.
Second.
Okay, Ms. Harkey moves to adopt staff recommendation. Mr. Horton seconds on items I2.1 to I2.12. Without objection, motion carries. Next item.
Our next item is the administrative session. Item N is the consent agenda. Item N1, we have retirement resolutions for Alfonso C. Barreto, Carla Caruso, Wayne J. Group, Patrick Mayers, Michaeline R. Orloop, Patricia Thomas, and James S. Wren.
Okay, so we would like to extend our appreciation to these retirees for their dedicated service to the Board of Equalization, we'd like to congratulate Alfonso Barreto, Business Taxes Specialist 1 in the out-of-state Chicago office. Retired in October after 17 years of state service. He began his career with the Board of Equalization in 1999 as a tax auditor in the out-of-state Chicago office. He promoted to Associate Tax Auditor in 2004 and Business Taxes Specialist 1 in 2010.
And we have Carla Caruso, a tax counsel 4 in the litigation division of the legal department, is retiring in December after 37 years of state service. She began her career in 1979 as a legal counsel in the criminal division of the Attorney General's office and was promoted to Deputy Attorney General 3 in the Public Rights Division in 1985. She joined the BOE in 2000 as a Tax Counsel 3 specialist in the legal department, promoted to Tax Counsel 3 supervisor in 2007 and Tax Counsel 4 in 2009. We wish her good luck and thank you for her service to the state of California.
Wayne Groupie. He was a business tax specialist 2 in the BOE's out-of-state Chicago office, retired in October after 28 years of state service. Wayne began his career with the Board of Equalization in 1986 as a tax auditor in the San Marcos District Office in Southern California. That's in the San Diego County. Wayne promoted to Associate Tax Auditor in 1992, and in 2001 was promoted to Staff Information Systems Analyst. In 2006, he moved to the Chicago District Office, where he worked as an ATA until he was promoted to Business Tax Specialist 1 in 2008. In 2009, Wayne was promoted to the highest field auditor position of a BTS 2, and we wish Wayne a long and well-deserved retirement. Thank you, Wayne, for your service.
Next members, we have Patrick Myers, who is a business tax specialist in the data analyst section, will retire December 31st, 2016, after more than 32 years of outstanding and meritorious service to the state of California and the people of California, as well as the Board of Equalization. Patrick, throughout his many years, has performed in an exemplary position. He has served the people of the state of California with fairness and dedication and preciseness and competence. Therefore, be it resolved that the Board of Equalization hereby acknowledges his retirement and wishes him well in doing so. Thank you, Patrick.
Michaeline or Mickey Orlup. Mickey Orlup, a business tax specialist 1 in the out-of-state Chicago office, is retiring in January after 10 years of state service. Boy, we have to get out to Chicago, find out what's going on here. She began her career with the Board of Equalization in 2006 as a tax auditor in the out-of-state Chicago office. Mickey was promoted to Associate Tax Auditor in 2008, and in 2010 was promoted again to Business Tax Specialist 1 position. We wish Mickey continued success, happiness, and good health in the years to come. Thank you, Mickey, for your service.
Patricia Thomas, Data Processing Manager 2 in the Technology Service Department, retired in October after 37 years of state service. She began her state career with the Fair Political Practice Commission in 1979 as an Office Assistant 1. While working at the Fair Political Practice Commission, she promoted to Computer Operator, Programmer 1, System Software Specialist 2. She was promoted to Senior Electronic Data Processing in 2005 with the Department of General Services. She joined Board of Equalization in 2008 as a Data Processing Manager 2. Congratulations, Patricia.
And finally, James Wren, Business Taxes Specialist 1 in the Consumer Use Tax section, is retiring tomorrow after 26 years of state service. He began his career with the Board of Equalization in 1990 as an assistant clerk in the Central Files section. He promoted to Office Assistant in 1990, Office Technician in 1996, Tax Technician 2 in 1999, Tax Technician 3 in 2002, Business Taxes Representative in 2002, Business Taxes Compliance Specialist in 2008, and finally Business Taxes Specialist 1 in 2011. We wish everyone a very, very happy and healthy retirement. Thank you. Okay, Ms. Richmond.
And then our next item is N2, approval of board meeting minutes for October 11, 2016, and October 25, 2016. Item N3, proposed revisions to Compliance Policy and Procedures Manual, Chapter 7, Collections. Item N4, approval of Assessor's Handbook, Section 581, Equipment and Fixtures Index, percent good and valuation factors, and item N5, adoption of property tax form BOE 261G, 2017 claim for disabled veterans property tax exemption.
Okay, we could take all these items up in one vote, correct?
Items N1 through N5
Yep.
may be taken in one vote.
Okay.
So moved.
Mr. Horton moves.
Second.
Ms. Stowers seconds to adopt staff recommendation on items N1 to N5. Without objection, motion carries. Next item.
Our next item is item P, other administrative matters. Item P3, business tax and fee deputy director's report. P31, effects of Proposition 10 on cigarette and tobacco products consumption.
Okay, welcome, Ms. Bueller.
Good afternoon, Madam Chairwoman and members of the board. I am Suzanne Bueller, Deputy Director of the Business Tax and Fee Department. With me today is Mr. Mark Durham, Chief of Research and Statistics. We have one item for your approval today regarding the cigarette and tobacco products Proposition 10 backfill. The Health and Safety Code requires the board to determine the effect of Proposition 10 on the consumption of cigarettes and tobacco products and directs a transfer of funds to Proposition 99 and breast cancer programs. The intent is to maintain the funding of certain Proposition 99 and breast cancer programs at the same level prior to Proposition 10. Staff calculated and determined that the backfill amount for fiscal year 2015-16 is $15.3 million. The transfer would be made from revenues received in fiscal year 2016-17 to backfill funds affected by the changes in consumption during fiscal year 2015-16. Therefore, in order to comply with the Health and Safety Code, staff recommends your approval to set the backfill amount at $15.3 million for fiscal year 15-16, and we'd be happy to answer any questions you may have.
Any questions, members?
Move to adopt staff recommendations.
Second.
Okay, Mr. Horton moves, Ms. Stowers seconds to adopt staff recommendation on item P31. Without objection, motion carries. Thank you. Next item, Ms. Richmond.
Our next item is P6, Administration Deputy Director's Report. Item P61, 2017-18 Budget Change Proposals.
Okay, there's a change in the agenda. Ms. Murphy is not here. Chris Holtz will be making that presentation. Is that correct?
That's correct.
And then we also have Mr. Randy Silva. So please introduce yourself for the record, and then you may commence.
All right. Thank you. Good afternoon. My name is Chris Holtz. I am the Business Management Division Director for the BOE, and I'm here to present two BCPs in this particular item. I have with me Randy Silva and also Suzanne Bueller, and we'll be taking your questions after we give a brief introduction to the two BCPs. On November 5th, the voters of the state approved two initiatives. Proposition 56 imposes a $2 per pack increase in the cigarette tax, while Proposition 64 legalizes the recreational use of marijuana beginning January 1, 2018. We're submitting two BCPs for your approval, and draft copies of those BCPs were sent to your respective offices last week. Just to clarify some confusion that might be still lingering on the BCPs themselves, they do look different than they have in past years. In other words, there are you see some estimates for positions and dollar figures for years beyond the budget year. This mostly comes about because of the new fiscal system, and fiscal allows the Department of Finance and departments to take a look at budgeting resources 4 years beyond the budget year. And these are just estimates, and as actual workload is gathered, adjustments are made to those for future budgets. So what you'll be voting on today would be the current year and budget year asks for these BCPs and not for out years. As we go and make adjustments for out years, you will see those proposals come before you for approval. I also want to tell you that we're working closely with the Department of Finance on these proposals, and that there is an understanding that the new workload associated with this is for new and expanding programs. As we discuss our update on department vacancies, and we'll get to that in the next agenda item, there's an understanding between finance and ourselves that this process will allow us to present our estimated new workload while simultaneously assessing those issues that are hindering our ability to hire and find consensus on solutions in the upcoming budget year to meet all of our goals. So what I'd like to do is just briefly introduce each of these BCPs. The BOE is requesting $6.7 million and 13.9 positions in the current year, and $9.6 million and 46 positions in the budget year to implement and administer Proposition 56. With this initiative, California goes from imposing one of the lowest cigarette taxes to one of the highest at $2.87 per pack. This measure also adds electronic cigarettes, e-cigarettes, and nicotine products to the definition of tobacco products for tax purposes. This request also seeks resources to complete the required floor stock tax on all stamped cigarettes and unaffixed cigarette tax stamps in the possession of distributors, wholesalers, and retailers on April 1st of next year. The state may see a decrease in actual cigarette consumption or a decrease in revenue as a result of this, but the state will also see a simultaneous increase in tax evasion as some consumers and retailers seek to avoid payment of these excise taxes. BOE staff estimates that current cigarette tax evasion in California runs at a rate of approximately $126 million annually, along with the $88 million in tax on other tobacco products. The exact magnitude of evasion efforts is uncertain, since the excise tax increase is significantly greater than prior tax increases. The BOE believes there will be substantial growth in criminal cases that will adversely impact program workload. The second BCP that we have before you asks for $2.7 million in the current year for 3.4 positions, and $9.7 million and 46.5 positions for the budget year to implement Proposition 64, the Adult Use of Marijuana Act. Prop 64 allows for the legal sale of marijuana for recreational adult use as of January 1st, 2018, and establishes a sales and use tax exemption for the sale of medical marijuana. The LAO estimates that state and local governments could eventually collect additional revenues of over $1 billion annually. Of immediate concern, Proposition 64 creates two entirely new separate tax programs requiring separate returns. The BOE will experience new and unique situations, including product tracking, customer service, return processing, audits, and receiving large amounts of cash at our field offices. The BOE assumes at this time that the number of retailers selling marijuana on January 1st of 2018 and will be collecting and remitting the retail excise tax would be 1,700 retailers. This is based on retail medical dispensaries operating in California currently. Although this proposition expands the buyer and distribution base, the BOE has no data on which to base a reliable estimate on the number of new retailers that may register with the BOE as a marijuana seller. Unlike other industries that typically have a small number of manufacturers and distributors with a larger number of retailers, the marijuana industry in California is unique as it has a large number of cultivators compared to retailers. The BOE is working with California Growers Association to gain a better estimate on what the regulated distributor market will look like. These growers are now required and will be required to register and comply, excuse me, with Proposition 64. And with that, I'd be happy to answer questions, and Randy and Suzanne are here to answer programmatic questions that you may have.
Ms. Harkey.
On both of these, well, in particular with the Prop 64, I think as we go forward, I think the 1,700 number is probably going to be smaller, or going to be larger. I'm already reading reports about things going in Adelanto and far out places like that. So I think we're going to have to maybe even do a 6-month look forward on this rather than letting this go. I've also got a lot of concerns with the cash and the staffing for that, and I'll be discussing those with the chairwoman to see if we can't come up with something that's reasonable. But that, again, I'd hope we could come back within 6 months. I'm very concerned for the field office staffing that I see in this going forward, and I think I'd like to see, number one, if there's some duties that can be handled in the district offices as opposed to in headquarters, and I'd also like to be sure that we are staffing the district offices to deal with just the enormity of which I expect this will be. So I'm hoping that, within 6 months we have a little better picture, and then again, don't be afraid to come back again and again and give us updates on this, because I think we're going to be hearing about it in our districts, and I want to be sure that we're staffing them accordingly. Thank you.
Ms. Stars.
Thank you. In the draft BCP, there was an estimate provided for cultivators. You didn't provide that estimate. Can you share with me what that number is and how that was determined?
For cultivators, right now the estimate that we are looking at is about 25,000 statewide. And that is determined through estimates that we are receiving from the California Growers Association.
Okay. So they provided you that estimate?
Yes.
Okay. So most of the PYs that's in the draft it appears that it's going towards investigation?
That's correct.
Yes. Okay, thank you. Why I'm getting like 35, 25 to investigation? Why so many into investigation and not within the audit programs?
I'll take a stab at answering that for you, Ms. Stowers. Randy Silva, Madam Chair. Randy Silva, Chief of Investigations, Board of Equalization. We're looking at an industry that is largely operated in the underground economy. And there's, based upon our experience both in the audit program and the investigative program, we don't anticipate that there's going to be a lot of people come in to voluntary compliance once licensing takes effect. So we're going to need to do some compliance related, which is the investigations division, inspections, looking at these cultivators, looking at these retailers, looking at these distributors, following the paper trails, following the money to make sure that the taxes are coming in as expected. And as to the audit question, I'll let you answer that, Suzanne.
I think that staff attempted to be very conservative, not knowing what the total population is. We're currently working with Department of Finance on language of once we start knowing how many actual retailers that we have registered, being able to then come back with another BCP based on the permit count changing. So at their request, we started out conservatively, but we certainly understand we'll be coming back, as Ms. Harkey had mentioned, and likely having another ask once we know better what this population is going to look like.
Okay, thank you.
So I have some questions. I have some questions. So how much do you anticipate we're going to generate in e-cigarette revenues?
At this time, I don't believe that we have an accurate estimate of that. This is a brand new regulatory and licensing piece that is going to be part of the program. So we don't have particular data for that at this point.
Okay. Well, e-cigarettes, have not had any sort of regulations, and anybody can sell e-cigarettes, whether you're a, manicure, pedicure, you can, your hairstylist, your liquor stores, as well as any other stores. Wouldn't it make sense to allocate more resources to scope, where these folks are actually out there, walking door to door, doing, the initial checks and education versus enforcement and investigations?
Yes, as far as the licensing on e-cigarette, that did begin with the special session bills that passed last year, and having more scope teams involved is a very good idea, and we do have a new team of scope positions that are within this proposal. As to how the scope teams work, I'll defer to the program folks.
Okay, so maybe someone can break down how many positions we're talking about: legal, field, investigations, and scope.
Well, on Proposition 64, we have, for the budget year, 22.3 positions that are part of the business tax and fee department, 9.5 that are part of field operations. At that point, within that amount, 5.5 are dedicated to the new scope crew. We have 5 positions that are part of admin and executive support, 2.5 positions that are legal investigators, 2.5 for external affairs, for outreach and publications, and 1.5 for the technology services division.
Okay, was that total, what was the total, 22.3?
22.3 for business tax and fee department.
Okay, so how many in the scope team? 4?
5.5 positions for scope.
And where are they going to be located?
That hasn't been determined yet. That will be up to Wayne Mashahara to work with the districts to decide where they go.
So this was, okay, so that's part of Prop 64 or Prop 56?
That's Prop 64.
64.
Mhm.
Okay, I thought you had 3.4 positions in this fiscal year and then 46.5 in the budget year, and you just gave us 22.3 positions.
No, the 22.3 was for the business tax and fee department.
Okay.
In addition to that, 9.5 in field operations, 5 in admin and executive, 2.5 for legal investigators, 2.5 for external affairs, 1.5 for the technology services division.
And that's for the current year or the budget year?
This is for the budget year.
So how much is that adding up to? Because that doesn't add up to me.
Yeah, that's,
I'm missing
just an observation. It seemed like it would have been an easier way to present this to us. The way you're saying it, it flows a little better that way compared to the draft BCP that was sent to us, and the breakdown of positions that was done by divisions or departments. And then you had the personnel service spreadsheet that was sent electronically. I'm trying not to kill any trees, so, and I could not rotate that document. Just an observation that at least had I had a breakdown, the way you're sharing right now, it would have been easier to follow. And right now, I'm still not sure on the positions by current year and budget year.
I'm not either.
Do you have a chart showing that, Mr. Holtz?
This is just taken from the positions as they're laid out in the workload estimates within the BCPs.
That's what I'm looking at. So what
Yeah.
page can you?
For the positions that I just laid out, I don't have that chart within the BCP. This is
Okay.
just
That was the
added
question.
from our budget shop as to what we are proposing for 2017-18. Or excuse me, for the budget year.
Maybe you could follow up with the chairwoman and provide a graph for her or a chart for her so she can see what we're adding.
Because
I
my
could
concern
certainly do
is
that.
it's very, like Ms. Stowers, it's very heavy on investigations and enforcement. And for Prop 64, if we're trying to bring a whole new industry above ground, I think we really need to be doing more in terms of educating them in a positive manner, in a kind of customer-friendly way, which in my opinion, in my districts, the scope team is very, very good at. Investigations typically goes in when there's a problem. I don't really know, who's in investigations, what they're saying, who they're meeting with. It's very, very hard for me to have that accountability. So I'm very concerned that it's very, very heavy in investigations, this budget, BCP. So I'm not really prepared to vote on this right now. And like Ms. Harkey, I'm more interested in having more people out in the field. Offices, doing the compliance, being kind of the face of the agency where people can come in and get information, and we're doing this proactive outreach initially before we, before the market matures and people are actually out there operating, and then we can, send in the investigators if there are really problems with people underreporting or not reporting. So that's where I stand on both of these BCPs at this moment.
Madam Chair, if I may.
Sure, Mr. Horton.
The Board of Equalization currently has a pretty robust outreach effort, and I don't know. I don't want to. Is it the department's intent that you would divert those resources in order to address those issues, to make sure that the individuals who want to comply with the law are actually educated? I mean, and then in addition, has there been an assessment to determine the extent of the education based on your numbers? It doesn't appear that you're projecting that there are going to be that many more retailers, and I'll address that later. But this system has been in place for 20 years, and under medical marijuana. And the presumption is many of the folks that are now selling medical marijuana will now begin to sell recreational marijuana. And so the education process has been going on for relatively 20 years here in California as to although I concur with Chairwoman Ma that there needs to be an extensive education as it relates to the changing in the law and with all the different variables out there. But in no means does that minimizes the necessity to address the reality that we're facing, the reality that has been faced in Colorado and every other state that has legalized that, and even here in California. In the city of Los Angeles, for example, we did a quick study in our district where we tracked down all of the dispensaries that are located in Los Angeles. And what we found is that 132 are actually registered in business legally under Proposition D in the city of Los Angeles. 400 of them are registered with the city of Los Angeles and registered with us. Some 1,600 exist and are just not registered, just here in LA. And the state of Colorado, with a population of 5.38 million people, nowhere near the 39, 40 million here in California, they have 25,000 dispensaries. So I think the numbers may be a little bit underestimated as to what the reality is. The other issues that I think we have to sort of be realistic about in this regard is, as Mr. Silver indicated, this is basically a criminal industry from federal perspectives. And given the appointment or the changing in the election, which is also going to change the attitude, it appears that the Internal Revenue is going to be a little more aggressive as far as taxation is concerned. And the new Attorney General has already stated his position, so that's going to cause somewhat of a freeze in legitimate activity here in California and throughout the nation. Not to say that, based on the numbers that we saw here in Los Angeles, there's quite a bit of criminal activities that exist. We all know that there are 3 different cartels that are involved in this business. There are a lot of folks that are doing it legitimately, that are really, really trying, and they're really fighting against this criminal activity, and they want to comply with the laws. The taxes on this is 15% excise tax, 10% sales tax, 18% state income tax, 38% federal income tax. There's a windfall there, or an incentive from just a taxation perspective, for you to continue to operate underground in the black market. And it's not the same as we experienced with cigarettes, where you had a structured environment both on the federal, state, and national level, but yet still we saw criminal tax evasion. If you look at the study done by, I think the Little Hoover Commission said that here in California we have over $9 billion in unreported taxable sales. And so the criminal element, we don't have to wait to see whether criminals are involved in the sales of marijuana. What we're waiting to see is whether or not the criminals will comply with the law. And if you look at what's happened in Colorado, they estimate about 40% non-compliance, and that state is nowhere near as significant as the state of California. Studies also say that there's anticipation that crime will almost double as it relates to individuals driving under the influence, children smoking the product, and so forth. And without some type of structure in place to control that potential criminal element and the incentives that exist for folks to operate in the black market as a result of Proposition 64 passing, with relatively little funding for actual police and oversight and criminal prosecution, and that structure not being in place, it's easier for the criminals. They have less exposure in selling marijuana now than they have selling any other drugs. And so without the penalty fitting the crime has a tendency to increase. And so I personally think these numbers are grossly understated as it relates to what's going to be necessary. If we look at our experience with tobacco, we had some, I think the legislation that I authored set in place 88 investigators. And that was an industry that was heavily regulated on the federal, state level, and the facts proved out that we needed that and more, and more. And so, in this criminal activity, even though it's legal now, it's from a state level, federal level is still criminal activity. It's just going to be the wild, wild west out there. There are no controls. They won't even go in place in 2018, and we really don't know in 2018 whether the track and trace will be in place, whether the funding will be in place, and folks can legally now begin to smoke recreational marijuana. I saw a kid walking down the street smoking. Police just drove right by because there's no incentive. And I've heard stories, and particularly with my chief of staff, where a child has consumed a candy bar that was, that had marijuana in it, had to be rushed off to the hospital. We're hearing these stories now, but quite frankly, we don't even have to rely on 20 years of experience here in the state of California to know that this is a criminal operation that we need to do everything we can to convert it. You can look at the experience in Colorado and every other state that has complied. There is non-compliance. Those who will comply, we need to educate them. Those who are not going to comply, we need to assist them in complying. And sometimes in assisting them to comply requires a level of investigation, a level of auditing, a level of prosecution, and so forth. And I think that's just the reality that we face. But let me ask a couple questions in this regard. Do we anticipate any of these positions having police authority?
Prop 64 specifically requires authority under PC 830.11, which is the board staff within Investigations Division for the purposes of conducting compliance-related inspections and seizures. And the tobacco products tax program, we also have authority for limited peace officer status positions. The positions we're asking for that are non-administrative are all limited peace officer positions. Just to clarify a little bit on the positions themselves, the bulk of the positions being asked in both programs, I'll start with 56, which is the tobacco, is really to backfill behind vacancies that have occurred over time within our district offices. So the bulk of these are inspectors, and what the inspectors do is they go into a business, they ask to see the invoices, they do what we call a reconciliation between purchases and inventory. They also do some stuff related to tobacco dating, and they scan for legitimate tobacco product or legitimate tax stamps with the current tax stamp. When they find violations, they will write either a civil citation, which brings the person to the board for a civil remedy, or if it's egregious, they'll write a misdemeanor citation, which takes the person to the judicial system to have to deal with the judicial system. Then they roll back into the civil arena. In the tobacco program, I think, as I mentioned, the bulk of the positions there's 13. Those are all in the field. There are some additional investigators we're requesting. Those are for doing the felony work. And what they do is basically follow the money, follow the paper, follow the product, and develop felony criminal investigations. And typically in our tobacco cases, the average case is $1 million in tax loss in the criminal felony cases. With regards to the marijuana program, we don't really, in the tobacco program, we have existing vacancies within some of our offices, within your offices, members, to put those staff. Within the marijuana program, we anticipate looking at the data that comes in from the Consumer Affairs to get a sense of where are all the licensees within the state of California. Again, that's highly based on 27 inspectors out of the total that we're requesting, and then some new investigators. And again, those inspectors would be somewhere in the field based upon what licensing data shows us.
Let me encourage Mr. Silva. I mean, I think it's important that we educate, and I think there needs to be funding in there to do the education for those who are interested in complying. As I said, I think there's a transition period between those who just may not comply simply because of their concern about federal prosecution and excess taxation, and that they may, in fact, may need some assistance in complying. And there are those that are currently operating in the criminal market, the various cartels that are not just going to get out of this business. It's a very profitable business, as everyone stated. They're just not going to back away from this, and their involvement will increase as it becomes increasingly legal, because the bright line test becomes a little, faded, and so you really can't tell whether the distributor is legal, not illegal, or whatever. And the Board of Equalization simply, even with this BCP, does not have the capacity to deal with this industry, to deal with these problems that we're going to face based on historical data as well as more recent data, and everyone else that has passed this, passed the recreational marijuana. And so I think we need to be very communicative and communicate exactly what we anticipate the issues are and what the problems are. How we quantify that as far as positions is another discussion, but to pretend that everyone just needs to be educated is just unrealistic. That's not the industry that we're dealing with. We're dealing with folks that are selling marijuana, or as kids call it, weed, for folks who will consume it to some degree, and that's the reality that we sort of face. So the suggestion is that our current auditors, in conducting these audits, are afraid to or concerned about their safety in going into these places, because you walk up there, they have an armed guard at the front door, an armed guard in the back door, and an armed guard inside. And so you're walking in as an auditor, you're putting your life at risk to some degree, I would certainly argue. So maybe in the audit process, we need to either have a police officer, or at one time we used to put in what we call keepers, where we would put in a police officer or highway patrolman would come in and allow us to do that one-day observation and so forth under the protection. And so when I ask full police authority, maybe we ought to consider some type of MOU with, through Trace and through Race, some type of relationship that doesn't necessarily deal with the criminal element, but just serves to protect our staff as they begin to conduct these investigations. With that in mind, does the BCP include any funding for the current problem of safety at the various districts that are accepting all of this cash?
The BCP does include more cashiering staff, the district offices, but since we haven't arrived at our solutions yet for what we might do for a cash acceptance location, we have not included that yet in the BCP.
But we sort of anticipate.
Yeah.
We've had conversations, the door's open, we will.
Yes, we have had discussions with Department of Finance as we've walked through our ask in the BCP and let them know that that will be forthcoming as we get closer to a solution.
Has staff sort of estimated what they think the non-compliance rate will be?
I think from what we have from the Growers Association, they're expecting non-compliance from the growers' perspective to be about 50%.
And how would you define non-compliance?
Not coming forward and being registered with the appropriate agencies.
And is there anticipated decline over the years, and what will it take to make that decline?
They did not comment on that, and staff
No,
has not
I'm
done that
asking
analysis.
my apologies for interrupting, but what's your professional advice? We've dealt with this before. We've dealt with this with diesel fuel. We've dealt with this with cigarettes. We've dealt with this with pharmaceutical drugs. We've dealt with this in the electronic industry. We've dealt with this in the motion picture industry. Mr. Silver, what are your thoughts?
Ask my opinion. My opinion is that unless you have some sort of enforcement-related element to the introduction of this industry into the mainstream, you're not going to have very good compliance. When we started, for example, with the cigarette program that you mentioned, we had 1 in 4 retailers selling contraband cigarettes. What I mean by that is counterfeit stamped cigarettes. Today, it's less than 1%. We've destroyed over 240,000 pounds of tobacco that have been seized over the last 3 years.
It's less than 1%, yet you're asking for more investigators.
But there's a $2 increase per pack, so I'm anticipating that things going crazy. Actually, right before this increase in the tax, I was looking at working with TSD on how to scale back and identifying the best offices to put people. That $2 tax increase is going to result in significant evasion. When they did the 50 cent, I mean, it was crazy what happened.
Yeah, I mean, to evade the law is just so simple. You know, at one point during this process, a container of cigarettes was worth more in the criminal market than a container of cocaine when you measured in the risk. And adding $2 a pack to it, as you said, maybe not as much as a criminal element, because I think we have a pretty good handle on that, but the diversion, and I think everyone would agree, is that instead of a decline in the smoking, you know, the question is, an individual who smokes cigarettes now is $2 more. Are they going to stop because they have to pay $2 more when they're addicted to smoking cigarettes? So cigarettes is on a real decline. People ought to stop altogether. An additional $2, I just don't know. And particularly when they can purchase it from out of state, they can purchase it from the local Indian reservation, commissary, all these shops that call cheap cigarettes and so forth. So the experience has been, as indicated, that there's just going to be an upswing in that activity. But I mean, this is something members, you know, I think I've been dealing with this for like 20-some years, so I apologize if I don't look at this through the rosy lens of, you know, an industry just is going to do the right thing. History just says that history, as well as the existing laws, even if they wanted to, makes it a little inherently challenged upon them. I mean, they have their legal advisors, their accountants and so forth are advising them don't report your full amount of taxes. Don't have records. Don't comply. And the federal government is posturing and so forth, is saying that, listen, you know, stay in the black market if you want to survive in this business. And the numbers that we see now, I mean, as I said, in LA County, there's 16,000, but only 132 are actually registered with the city, and 400 registered with us. And so that's a huge non-compliance, well over 50%, you know. And I see no incentive for them to come into compliance, but I do think they ought to be educated.
I just have a couple things. I do feel in my district we have done a lot of outreach to this industry, and compliance has gone up. More and more dispensaries have been registering, have been trying to figure out what type of licenses they need, how they need to pay their taxes. And this is an industry, as you know, that hasn't been regulated. It's been kind of self-regulated, trying to do whatever is right, being a level 1 scheduled drug. You know, anybody who's associated with the industry also can fall under the same, statutes, and therefore a lot of CPAs, accountants, bookkeepers, payroll services, they have not been advising or servicing this industry. So a lot of them have just been trying to do whatever they think is the right thing. And I think, now with the passage of Prop 64, there are more professionals that are willing to take the chance and are out there now saying, hey, we want to educate and advise folks. I think we want to, bring this industry into the open. We don't want to drive them back into the black market. I think, scope teams are the appropriate folks who are out there versus investigations, which I think will scare people and not encourage them to apply. So, come into compliance. So that's my opinion. I'm not comfortable also, with our folks having guns. As I have said to Mr. Silva, it makes me uncomfortable. I believe we are tax collectors and we are tax auditors, but we are not law enforcement, and law enforcement should be, left to the CHP, the police, the sheriff. I think those are the appropriate people who are trained in law enforcement. So that's just my opinion, and I'm not ready to vote. If you think for the tobacco, you need all these extra investigators to go out because of the $2 pack, I can't tell you, but that's a very mature marketplace out there. So I think we're talking, apples and oranges. This industry is not mature. We don't even have any regulations for a state licensing mechanism right now. So, asking for all of these positions for what may or may not happen, I think is premature at this moment. As you know, the local governments have to license these folks before they can come and get a state license. So, trying to get all these people employed, sitting around waiting to see how many people are going to actually get these licenses, I think is very premature. And again, I prefer to put more resources into our scope teams, who I think are doing a great job. I know my district that are really going out there educating, gaining the trust for this industry, and we have seen an increase in compliance. They feel like, we're trying to help them comply and not trying to go get them, which I think is what we have been trying to do in our district. So,
Madam Chair, if I,
Well, yeah, a couple questions I have. One is, first of all, let me talk about the tobacco issue. One of the things I think I heard was that we were asking for positions to backfill our vacancies. Did I hear that correctly?
They're not actually vacant positions. We staff each office with 5 inspectors,
right,
1 lead, and so we have offices because we don't have the positions. Over time, what happened was, I don't remember how far back, Scoop used to be part of the investigations division, and we transitioned that to the districts. And when that happened, it created some of these offices now, instead of having full complement of 5, have 3 or 2.
Well, what happened to those?
And use tax during the Scoop program.
So we actually transferred in the midst of scope. That was a budget drill. So the budget actually changed positions and moving people from investigations to scope.
That's correct.
And so now what you're doing is you're not backfilling vacancies then. What you're doing is you're just adding the additional positions
To staff the
to
offices
staff
to
them
work at
up
night.
to where they were in the past.
Right.
That's right, and this is completely a
Is that part of the
completely different
legislation?
issue from the vacancy
I guess
issue.
I'm a little baffled. I'm surprised right now. I guess I'm thinking through. The legislation and the legislature changed our positions to go from investigations to scope.
It was done through a BCP process. It's been a number of years ago. I don't remember exactly when.
Okay. Let me just, okay, so I agree. I think the fact is the new amounts are going to put tremendous amount of incentive out there for illegal activity. So I do believe that we're going to have to have we're going to have to be prepared in a robust way for us to deal with that. So I just think that's the nature. It's certainly, all we need to do is look at New York and see the high in non-compliance rate in New York, which I think now has I think we're very close right now. I think in tax, but they're probably still a little bit higher. But again, they're experiencing large non-compliance and black markets. So I think that makes sense to me. I'm a little more concerned and interested in the issue of investigations on the recreational marijuana. How many positions do we have in this BCP for the investigations in the marijuana?
Within the legal department for the budget year, we have 2.5 positions that'll be starting in budget year.
And then how does it go up to? What are you projecting? The budget year would be 17-18, right?
That's right.
Okay.
That's investigators or inspectors?
Investigators.
That would be investigators.
Those are investigators.
And how many inspectors?
Within the BCP itself, projecting out to 2018-19 and 2019-20, we anticipate a total 23 business tax compliance specialist inspectors, 4 business tax specialist 1 lead inspectors, 4 business tax specialist 2 senior investigators.
Help me understand. So again, okay, let me go back a little bit in terms of the budget year. What is the role of an inspector versus an investigator?
Inspector does inspections.
And is an investigator, let me ask you to clarify before you go through that, Mr. Silva. Are both of those in the legal department?
Yes, Mr. Ryan.
Okay, so the inspectors and the investigators reside in the legal department.
They operate under the legal.
And how many, so let me go, before you go and answer your question, how many investigators then are there in the budget year?
Investigators in the budget year would be 2.5 positions.
Oh, I'm sorry, I thought that was both of them? First I asked investigators.
Investigators is 2.5 positions.
And inspectors,
would
excuse
not
me.
be coming on until the 18-19 fiscal year.
18-19, okay. Okay, so quickly tell me real quick in terms of what's the difference in terms of that process between an investigator and a inspector?
Okay, an inspector goes out into the field and inspects all the different licensees currently within the tobacco products program. And they look at their invoices, they look at their purchase invoices, if it's a distributor, their sales invoices, they do this thing called tobacco dating,
Okay.
they do reconciliations of a tax stamp in terms of scanning to verify that the product's all legitimate. And they also will assist the taxpayer with any information that they want when we're out there.
Okay.
They issue civil citations, which are handled internally by the department. Those are usually for violations, small seizure amounts. They don't have documentation to support the product is tax paid. They also issue criminal citations for larger seizure amounts, but not astronomical. They conduct seizures of contraband products. The investigators work the felony level cases. They're the ones that they all work with other law enforcement agencies in a collaborative fashion, but the felony level solely do criminal investigations that result in incarcerations for large amounts of
How
tax
many
evasion.
investigators do we have right now assigned that are doing medical marijuana?
None.
Okay,
Well,
so,
can I correct that? We have done some sales tax related cases on medical marijuana.
right, okay.
But there are no.
Right, they've been doing on the sales tax side, not,
Right.
yeah,
There are
right.
no
but-
specific.
Okay, so help me understand then, what is the role of the investigators, particularly in the budget year? What are they investigating? Especially since we've apparently have not have a need for investigators for the medical marijuana. What has created the need and the opportunity there that we feel like we need to do for recreational, especially when it's not even sold the first half of the budget year?
And I misspoke and confused the issue there a bit. And looking back over the BCP, the 2.5 positions would be associated with inspectors and not with investigators.
Okay, so those are inspectors.
Yes, and they start in the 17-18 fiscal year.
So what is the difference between an inspector then, if again, I'm thinking about marijuana, not so much, I get what we do with cigarettes, because, I mean, there's stamps, there's counterfeit, there's all this other stuff. I don't see, right now, I'm trying to get my head around the fact that you've got cannabis out there that, I'm trying to figure out what they're actually inspecting, as opposed to auditors who are just saying, are you auditing, or are you, or are we are auditing to see if they're collecting tax? I'm trying to figure out, I guess, we don't even have a system for them to actually to inspect right now, do we?
No.
No.
It's still under development. As I recall, and I'll have to look at this more closely, what we were trying to do was bring some folks in, a small number, to start learning and getting more information on the industry.
Okay.
And developing policies and procedures. We don't start to bring the bulk of the staff in until later in 18 and then in 19 to start doing some of the work. Now, at some point, there's going to be track and trace.
Right,
I don't
right.
know what
So
that
we
is. I
don't-
mean, there is a requirement to be out there. When that comes into play, we will be looking at that. One of the things we'll be looking at, though, that does take effect sort of immediately when the licensing kicks in, is a requirement for documentation. And all I can do is give an example as what's happened in tobacco. In tobacco, the taxes went down to about $40 million a year before the inspection program was implemented. And tobacco, I'm talking other tobacco products, don't bear a stamp. That amount now, even with a 19% decline in the taxes, is $89 million. So there is some value in having people out there looking at the invoices, working with the taxpayers, and if they're in possession of untaxed, which at this time it'll start to be in possession of untaxed marijuana, then take an appropriate administrative action.
Okay. I guess I'm a little perplexed in trying to get my way through exactly what inspectors are doing that early. Now, actually, Mr. Silva, the thing that actually resonated a bit with me was the fact that we probably need to bring some people on early in order to start figuring out what the game plan is. In order to be prepared when it is that the regulation is in place. But I'm also interested in feeling the same as the chair, in that it seems to me that I think we have to have at least as an aggressive outreach program to these to these folks in regards to what they need to be doing, how they need to be doing their work, what they need to be, to me, which is not necessarily as much as a threat to the industry as much as it is, hey, we want to help guide you to compliance. I guess I'm not seeing right now in the BCP that there's as much emphasis on that aspect of it as there is on the other side. So I guess that's the balance that I'm concerned about. Tell me about where we are with the timing of this BCP right now. If indeed, particularly the marijuana one, I'm fine with the tobacco one. The marijuana one, what is our timing issue? If we were to come back and deal with this at the next meeting, try to get a better understanding of outreach versus inspection, all that, where does that put us in the timing?
Timing on this is very tight, since this was a late submittal due to the fact that it was passed through initiative.
Right.
Once the initiative passed, we had 10 days in order to give a draft to Department of Finance, and we've been working with them back and forth on the level of staffing and funding. if this were not to pass at this hearing and wait until the December hearing is right about the time frame when Finance and the Administration would be closing down their budget and making final decisions. Now, that doesn't mean that we can't revisit this in the spring process.
The budget process.
Right. But it would be extremely tight to wait until another
Basically, what we
hearing.
don't do is we have a challenge with getting then integrated into the governor's budget proposal.
That's right, plus the current year needs that we would have. We have 3.4 positions in here for current year registration needs and programmatic needs. That wouldn't be happening without the BCP going forward in the Jan 10 budget.
Okay.
Ms. Harkey.
Hi, I want to thank you for bringing this forward, and I am quite honestly very pleased with the robust discussion of all of this. But I do think that there is a different approach, and I actually know there's a different approach between Northern California, where the industry is established in a cottage fashion, and Southern California, where it's supposed to go big. And I heard that from the treasurer and others, that Southern California is supposed to have the big permitting and the big issues, and we have the huge population center. So I do feel that I understand the chairwoman's concern and what were probably Ms. Yee's concerns. However, I don't think they focus on the really big issues we're going to have in Southern California, where we have the cartels. I do believe that L.A., Orange County, San Diego, Riverside, those areas are going to be hugely impacted. And, they are already. And the land is being bought up, the facilities are being permitted, that's where the large grows will be, indoor, outdoor. And we already have heavy cartel influence down there now. And I don't believe this is just going to go away. They're going to come forward. I think there's going to be, and to quote in the legislation, there really are no public safety funding options in the initiative that was passed. It was envisioned that we would need, fish and wildlife or fishing? Yeah, fish and wildlife, because of the forests in Northern California and the poaching and that's going on, that the degradation of the environment from the poachers. And some of the local sheriffs need to be reimbursed. And so there's some small amounts of public safety funding, but mostly focused, when I was tracking that legislation that went through on the medical, and as I've as well examined the initiative, it's mostly based on a cottage industry that is not going to be cottage in Southern California. And since there is no public safety funding, I really think we need to go forward with this. It will be brought back in 6 months. I think we need to get boots kind of on the ground to figure out what we're going to have to be doing. I think there's going to be a lot of enforcement in Southern California, as well as education, but you've got to be sure that you can handle the existing cartel activity down there, and you're not going to get a scope or an auditor to go in the middle of that. It's just not going to happen. It requires a little bit more of an underground kind of surveillance type of thing, and I quite honestly think we need to be very aware of that. Our staff right now don't feel comfortable just walking in, as Mr. Horton said, because of what the existing industry has. And that's not to say we can't get our hands or our arms around this, but I do believe as long as there is still federal restrictions and it's still a Schedule I drug, and there's still going to be issues with potential federal seizures of property, bank accounts, whatnot, we're going to be facing this for a long time. So I don't really want us to go off into, staffing such that we're staffing for the cottage industry that exists, that is coming to the fore and being legalized, versus what we're going to be dealing with in the huge providers of this and what we are currently dealing with. So I would like to see us go ahead with these BCPs and have them come back in 6 months. We're only approving the current year and the next year. We are not approving forever, but I think this gives us a guidepost of where staff thinks we may need to be. And I think there will be a look back. I do believe we need to have education. And so I would like to see that come into play. But since this all doesn't go into place until 2018 on the recreational, I think we probably have enough education, and we're trying to do on the medical right now. And as a matter of fact, you see it in the report in the papers that medical is exempt. Well, that's medical if you've got a permit, according to the BOE, but that's not what's coming out in the papers. So it's just, oh, tax holiday. So I think there's a lot of misinformation right now that we can work educating in our own offices and getting out with, you know, however it is we're going to track who should be permitted and who's not, and that's probably weed maps and other public publications or public sites. Chairwoman, I hate to see this just stop in its tracks. I think we're going to need a few people on the ground now, you know, while we get ready for this to try to prepare, and then we're going to need to have a look back to see what we really need and in what areas we need it. And it may be that there'll be less impact in certain areas of the state, and there'll be more in other areas of the state. I think the experience in Colorado and in other areas has shown that the cartel activity does not go away. It merely becomes the breeding point to get it out across the rest of the nation. And that's what we want to kind of control. And I think we can do it in California. I really do think we can do it. But this banking issue will continue to be a problem. And so until we get all these things kind of lined up and knowing that we have really no public safety funding, I think it's very important that we at least have some kind of street smart investigation process that can at least, you know, give a heads up to where the issues are, who we might be needing to assist versus who we might be needing to encourage to come to the fore. I think it's going to be twofold here. I think the medical marijuana, we can start bringing those people in now. I think, you know, that will probably in most cases that will convert to recreational or could convert to recreational. But I think it's important to get those people up and running and registered now. And then to go, you know, to be sure that we're prepared for 18 and that we know what's actually on the ground. And so I would like to see these go forward for the first, it's only this year and next year or the next budget year that we're staffing for. It's not a lot of people, but I think it's necessary for us to at least understand, get a little idea what we're dealing with, and then come back to this board within 6 months and say, hey, this is what we're seeing. Maybe we don't need this. Maybe we need a little more of that. And I'm more than willing to do that, but I do not want to say no to these right now because time is of the essence. And we won't get another, I think if we're just working with Department of Finance and trying to get them used to what we're doing in our regular staffing, let alone adding this, I think the credibility of the board's at stake, and we need to be sure we're at least, or we're going to be blamed for not enforcing the program. I mean, you know, you have to kind of know what you're doing first, and everybody's kind of got their sea legs now. Nobody really knows how this is really going to work. I think there are a lot, like I said, there's a lot of places that are trying to do it right, coming into the fore, as Chairwoman Ma has said, but there are a lot that won't be. And I just don't see my auditors or my scope teams going out into those areas and being any kind of, you know, super sleuth. They've got other industries they'd probably feel a little bit safer doing that with. So we see some of the people that come before the board. They don't have books and records. They've got, what are those dogs? Dogs in the backyard, and you know, they're not, you know, they're underground now. So I think there's a lot that we need to be dealing with here. This is an interesting foray into trying to legalize what has been, or what is still by the federal, but what has been in California illegal and black market. And I don't think we can be naive and say they're just going to come forward. I don't want to be there. I want to be sure that we're at least covering ourselves and know what we're getting into. And we can always pull back, but we're not asking for much here. This is not much. And if they've been working with Department of Finance, I'd like to see it go forward. So I am going to make a motion to support these, and hopefully I'll get support, to support these BCPs and request a the staff to come back in 3 months and in 6 months and let us know where they think they are.
Madam Chair, I would second that motion, but I would say there may be a solution, and Member Harkey may have sort of framed up that solution if staff can maybe articulate on this suggestion. And that is that if the members are of a mind that, and I think all of us seem to be of a mind that education is necessary, and if you look at the numbers, 50-50 ratio, 50% compliance, 50% non-compliance, that means you have a significant number of folks out there with the appropriate education, with the appropriate structure in place, who will come into compliance, as been experienced throughout California. Not only in Northern California, but in Southern California, we have seen an increased number of people who want to comply. They simply can't, because prior, the law didn't allow for that. You know, in LA, for example, only 132 licenses were issued. So you had to go out there and violate the law, you know, and only so many folks could comply because of their concerns about the federal prosecution. And so to the extent that that education can occur and bring those into compliance, along with the reality of the 50%, so a commitment from staff to come up with a plan that another BCP or incorporate something in this BCP that addresses that education, but not necessarily minimizes the need to have the enforcement in place, because January 1st, 2018, you're not going to put 2 investigators to work January 1st, 2018, expect them to do anything for a good year and a half. So you might as well get them up and ready to go. I think the growers or the cultivators, we had similar issues, as you may recall, when we were addressing tobacco tax evasion, in that the industry was concerned. They were concerned about the Board of Equalization overly aggressively coming after them, until they realized that the Board of Equalization is only going after the tax evaders and not the folks who make mistakes. You know, folks who make mistakes in taxation ought to be given a second chance to some degree. But there is a group out there that will be evading the taxes. Even the cottage industry, they're going to face the Mexican mafia, and they're going to face in Canada imports and export the products coming from all over the world, folks traveling to Europe and bringing the product back and so forth. Currently, Mexico grows a significant amount of this product. And as soon as the gates are open, you're going to see the trucks flowing into the state of California if the regulatory system isn't there in place, as we've experienced over the last 30 years with so many other industries. Despite the education that has occurred, I think, over the last 40 years, we still see $9 billion in unreported taxation, according to the UCLA study. We've been an enormous amount of education. I think what that tells us is that the industry itself, the legitimate operators, if they don't have the Board of Equalization protecting them from the illegal operators and leveling the playing field, they're going to be put out of business. You know, the criminals will force them out of business because they have a competitive advantage. They have a competitive advantage from a tax perspective, competitive advantage from a distribution perspective. Their distribution system is already in place. You know, you can go on the internet and locations, thousands of locations will come up where you can actually go and purchase this product. Walk down Venice Boulevard and you can purchase. So their distribution is in place. And the only thing that can protect the legitimate operators is enforcement from those who are going to violate the law, whether that's 10%, 30%, or as you have estimated, 50% of the individuals who are just anticipated are not going to comply with the law based on what's happening in New York and Canada. So I think a conversation, if you will, with the cottage industry and with other folks to get them to understand that our job is not to put people out of business. Our job is to level the playing field and make sure everybody pays their fair share. And so in that environment is where legitimate operators thrive. Those who want to comply with the law, they thrive because the store a block away the Board of Equalization is investigating them. And they're no longer undercutting them and selling it, or shall I say the corner across the way, as the case may be, whatever the case may be. So I think there's a real upside to the legitimate operators who want to comply, to educate them, and I think it's in the legitimate operators' best interest to level the playing field. And when I said policing, everyone knows to my detriment, I've sort of fought this whole policing thing, having guns, and I agree with the chairwoman in that regard. But I do believe there needs to be a memorandum of understanding with the police department or someone else. We've got to fund a collaborative working relationship to protect our staff. Otherwise, we just can't ask them to be on the front line with a pencil and pen and expect to dodge the bullet. I mean, we can certainly make policy based on the exception. But in this case, both the exception and the rule can result in the loss of life. And I certainly wouldn't want to err in that regard. We know what we're facing here with this industry. Anyway, Madam Chair, I think she has some.
I just have one quick question. Looking at the BCP, you guys also for Prop 64, there's a couple of BTS, Business Tax Specialist positions down for civil audit within legal specialized operation branch. Are these individuals going out to the field to conduct audits, or are they just looking at the documentation that the inspectors or the investigators receive during their investigation?
They look at what has been obtained through search warrants and subpoenas for criminal investigations.
So they're safe. They're not out there.
They're not out, that's correct. They're not out in the field. We also get the cases brought into us by other law enforcement agencies that have audits, and so we do those audits as well. But the records are all coming in for those staff.
Because I'm like everyone else, I'm concerned about anyone out there trying to look at the records. I respect that at least the investigators and inspectors are trained and will have the limited peace officer status. If this was approved for the inspectors, it's 2.5 for the current budget year, and you guys will come back to us in 6 months to talk about the other 21.5 inspectors? Is that what we're saying?
The way that I understood that is that we'd be coming back in 3 and 6 months to discuss additional pieces having to do with educational outreach, having to do with other issues that you all are pointing out are not part of this proposal. But as we move forward in the process, not just with finance, but then also with the other departments that are involved in this, consumer affairs, food and ag, fish and game, DOJ, as all those pieces fit together, then we would come back to you and discuss with you those types of things that we are suggesting move forward in conjunction with the entire administration's viewpoint of how this program, how this initiative is going to move.
Would that include revising the number of inspectors and investigators if it indicates that you don't need that many?
If the data that we're looking at says that we don't need that many or that we need more, we would come back with that information to you in the spring.
I can appreciate that, but when you come back, I think we should talk about the format and how you present it to us. The way it's presented right now is impossible to follow.
Now, as a policy, could the board direct the department to only for the investigators to serve in a capacity of educating, observing, analyzing, and only engage in the more aggressive activity when there is clear evidence of criminal or evidence of a need without quantifying or defining that need, which I think is what they do anyway. But it appears to be a consensus on the board that there needs to be a level of education before there's the aggressive enforcement. And from my recollection, the inspectors actually do that. They actually, unless they see something terribly wrong, they're not issuing citations, they're not, setting people up for criminal investigation or something like that. And much of that work is done behind the scene as well. But to the question, as a policy, is there a way to assure the board that these investigators are not being overly aggressive and they have some instructions to participate in a level of education until there's evidence to the contrary?
Mr. Horton, we currently do about 10,000 inspections a year in the cigarette and tobacco products arena.
I'm asking a leading question, so go ahead.
And of those, a very small number result in a violation. But they also, the inspectors provide insights into where some of the more felony criminal activity is occurring because of their presence within the particular industry. And
Of the 10,000 of the 10,000 that you mentioned, what percentage of that actually results in some type of?
I was afraid you were going to ask me that question.
You can guess.
It's a small percent. I'll have to get back to you. I don't know it off the top of my head.
Under 10?
Pardon?
Under 10?
It's under 10%.
Under 5?
I want to say somewhere between 10 and 5, but I really need to check to give you an accurate
That's
answer.
the ballpark.
So the greater percentage of their activity is education and assisting in complying or
That's correct.
Awareness. All right. Thank you.
I'd like to split the two votes. Again, I'm just not comfortable having so many investigators out there. I like the scope team because those folks in scope actually work with the different groups within an office, and they sometimes, move out and become, an auditor. They don't stay. Investigators stay as investigators. I think investigators look at cases differently than the scope team members. I'm just not comfortable at this time until we get a better handle of how many people are out there, how many people are really complying, and that's how I feel. So.
I'm going to be fine supporting both of these. However, I think my concern is when we come back in 3 months. The 3 months allows us then time to adjust whatever we're doing. They'll be in the very beginning time of budget hearings and committee hearings over there. So, if we find that we can make an adjustment, we can certainly make adjustments from our point of view at that time. But what I'd like to see us do when we come back is I'd like to make sure that what is presented then to us at that time is a field-based outreach program. What's the plan? I think right now I hear about outreach, but it sounds like it's like a Sacramento-based outreach program. For instance, when you talked about outreach and scope and all those things and compliance, I don't know if you had much conversation with the field offices about it. And so I'm interested to know that we have an involvement in the field offices in regards to what they believe, since they're out there auditing these folks a lot of them right now. What do they see then as what we need to be able to do to have a field-based outreach program and integrate it into this? So anyhow, just if that could be part of it, that'd be great for me.
I just got told that there were 800, citations or whatever out of 10,000 investigations, so that's less than 1%. I don't know if that's right or not, but.
Is that tobacco? Is that under tobacco?
It must be. Yes.
Move adoption of BC change relative to Proposition 56.
Okay. Mr.
Second.
Horton moves, Mr. Brenner seconds. On the BCP related to Prop 56, I think without objection, motion carries. And on item number P6B.
Move support of the BCP with a 3-month review and a 6-month review.
I second that, but I think it's grossly understated if you ask me, but I second it.
Okay, Ms. Harkey moves, Mr. Horton seconds with a 3- and 6-month review. Can you take a roll call vote?
Chairwoman Ma?
No.
Ms. Harkey?
Aye.
Mr. Horton?
Aye.
Mr. Renner?
Aye.
Ms. Dowers? No. Motion carries.
Okay. I think we're going to have a conversation about vacancies now. So for those that want to stay, talk about how little or how many people is,
I do.
I know. There you go. Okay.
So our next item is P62, vacancy update.
I also wanted to introduce Sandra Mayorga. She's our Chief of Human Resources. And we've been asked to give you a report on the status of BOE vacancies and update you on the development of the BOE plan to reduce vacancies as approved in the concept paper that was voted on at the August hearing. The BOE has been required, beginning with this fiscal year, to provide a monthly listing of vacancies. Provision 3 of our main budget item requires the collection and reporting of the total number of existing vacancies in the department, including position title, department or division which the position is assigned, the date the position became vacant, whether the vacant position is in active recruitment. We've now gathered 5 months of data on that, and the numbers were sent to your respective offices in a PowerPoint chart. They've also been sent to the legislature, finance, and the LAO. As of November 1st, there are 613 total vacancies existing at the BOE. Of that amount, 354 of them are either in active recruitment or they are on paid leave of absence. And these numbers have stayed fairly steady. The 5 months of data have shown the numbers to be fairly constant. That's to say that the November numbers are very consistent with each of the months over that time period. So just very briefly, I want to address some of the program and budget considerations that we're looking at in developing our spring proposal, which I plan on bringing before you in January at the January hearing. First thing I want to point out is that there's been very positive progress in reducing the number of positions, full-time positions, that are in our temporary help blanket. As you're aware, there have been many issues in managing and addressing positions in the blanket. In 2014-15, the BOE overspent its temp help blanket budget, spending a total of $14.5 million on 247 positions in that year. As of July of this year, that expenditure had been cut nearly in half to $7.5 million. Currently, there are 102 positions in the blanket, of which only 16 are classified as permanent full-time. Those positions need to be pulled out of the blanket and be moved into those positions that are vacant right now. By July 2017, we expect temp help budget expenditures to match the historically budgeted amounts of $3.5 million. Now, there are many factors that we've seen in our high vacancy rate. These are well known to all parties, both within BOE and external, and they are understandable obstacles for departments that are the size of BOE, and other departments have the same issues. What the administration and the legislature want to know is how we're going to overcome those obstacles, where we can reclassify positions to fulfill existing workload, and what controls are in place to manage future positions. And what we've seen are 4 main areas to address, and I'll speak in more detail about them at the January hearing. First, we talk about the temp help blanket. We're identifying the current positions that are not appropriate for blanket funding and identifying vacancies where they can be moved. Next, the hiring and recruitment process, which is long and somewhat confusing to applicants that are coming into the state for the first time. Changes are in process to expedite the hiring process through the ecosystem. Departments must make renewed progress in accelerating the listing of current vacancies. So we're attacking that from both ends, both from our processing within human resources and accelerating the hiring packages that are coming in from the various departments. Third, we will help identify prior year savings to help redirect these efforts toward needed hiring. In the past fiscal year, BOE reverted $13 million in funding for personal services. Analyses are in progress to determine how this can be managed in a more effective manner. And finally, we'll be recommending a reevaluation of the staffing model that is used by field operations to allocate resources to audit and compliance staff in order to remove any obstacles to hiring and identify ongoing base business needs. And as we've stated throughout the presentations, we're continuing to work closely with the Department of Finance on this issue and integrating that together with the new workload proposals that we're bringing forward. And we'll be integrating that also in the spring with the various audit reports that are coming due and our facilities plan that's due to the legislature in February. So in the springtime, we anticipate a convergence of all of these various plans and reports, and that will be our presentation along with the Department of Finance that will shed a lot more transparency on the process that we use in filling vacancies, as well as some of the other issues that are part of the supplemental reports and the ongoing audits. And I'd be happy to answer any questions that you have on the current vacancy issues.
Mr. Renner?
Yeah, one of the issues that we've dealt with in the past, that we're having to do ongoing issues that we've got to deal with, and that is the issue of staying on budget versus our vacancies. Have we established how many vacancies we have to maintain in order to stay on budget?
At this point, I don't have a definitive number of vacancies that we would need to stay on budget, but what I do emphasize to people when I'm talking about keeping vacancies open and kind of the salary savings mentality,
right,
is that the state seems to be moving beyond that. We don't budget for salary savings anymore. We are moving toward more of a true budgeting model and looking at position transparency rather than the old government codes where we eliminate positions that are vacant for more than 6 months and just budget an extra 5% in order to meet salary savings. If we were to budget an extra 5%, that's a little less than half of what we currently have as far as total vacancies. But we're moving away from that, and I know that...
You say we're, who's the we're there?
When I say we're,
who's the we're there?
I'm talking about finance and all of the state departments that are dealing with positions.
In their current discussions with finance, are they open to adjusting our budget to ensure that we don't have to do the plan that makes us keep vacancies in order to balance our budget? Is that what you're saying?
That's what I'm saying, and that finance is open to what they really want, and what the legislature wants is transparency and to work in partnership. And yes, finance is moving away from that model, and in all of our discussions,
now that's a pretty big adjustment that they're going to have to make, though, when it comes then. Are they prepared to? Do you believe they're prepared to do that in their upcoming budget?
In the upcoming budget, it's been a challenge in prior years' budgets. They replaced the salary savings with the budget transparency.
So if
piece.
they're not willing, if we can't get there in this next budget year, 17-18, are we prepared then to determine where it is that we should hold these vacancies?
Mm-hmm.
What are the best places to us to hold these vacancies? Because what I'm concerned about is that if we've got to hold vacancies, I just as soon have us be strategic about it.
Mm-hmm.
Where do we hold these vacancies? Where does it make sense to not to work with less people in order to get the job done?
Yeah.
And I heard you make mention of the field staffing model. But it seems to me that and we've talked about this before, in order for us to have a plan to hold vacancies, that's going to require some kind of a staffing model at the headquarters.
What we're seeing with issues involving the staffing model and issues involving ongoing budgeting related to keeping positions vacant is that staffing model is setting a certain percentage, about 75 to 80% of the workload for the field, and then staffing to that workload, not going to, say, 85 or 90%. Then positions are filled through an attrition process rather than filling current vacancies that are outside of that staffing model. They are filling positions. Once a position becomes vacant in the field, that position is then determined to move to a field office that has the workload and then filled. So the process of filling positions out in the field right now is restricted by the staffing model, and that has to be evaluated so that restrictions
The restriction is waiting
come
for
off.
attrition?
The restriction is waiting for attrition and budgeting toward a lower audit and compliance workload in the field than would be available under full staffing if all vacancies were filled.
Again, my question, I guess, is still the same, and that is, we have a staffing model that we're apparently deciding not to fully fulfill in the field, but yet we have no staffing model for the headquarters. So my question is, maybe it's more important for us to fill the vacancies in the field and hold more of those vacancies at headquarters. And I don't know what process we're doing to evaluate that.
At this point, we're advocating reevaluating the staffing model to remove those restrictions rather than putting more restrictions on headquarters and less on field, or vice versa.
Apparently you're not feeling the need to have a staffing model at headquarters?
When we have a budget reversion of $10 to $13 million annually in personal services, there has to be a second look in how we are filling current vacancies and doing existing workload that we have identified
But
for those dollars.
how do you do that if you haven't done any kind of prioritizing in regards to where to maintain those vacancies? For instance, I don't know right now whether or not we should be maintaining vacancies in legal. Is that the best place for us to do that, or if we should be doing it in other aspect of headquarters? So I don't know. And I don't know if we've ever, I guess I do know. I do know I don't believe we've stepped back to say, where should we maintain these vacancies in order so that they make the least amount of impact on the mission that we have?
If I can interject just for a moment, on your comment of the staffing models in headquarters, I can tell you in the Business Tax and Fee Department that we are currently working on a model for our collectors and our auditors. The collectors one is a little further along because we have more data to be able to do something similar like the field has, and we are also working on the audit model as well.
So why would we be doing staffing models based upon departments and divisions as opposed to an overall staffing model for headquarters?
We approached it this way because it's the type of work. So we're grouping like work and doing a model for what does it take to do collections for this many accounts, given that it takes this much to work.
I guess the bottom line for me on this discussion is, I guess I don't feel comfortable right now that we are aggressively looking at what our staffing model should look like, what our staffing level should be in our current, and where we maintained vacancies when it comes to the headquarters. And so I would ask for us to do that. I would ask for us to say, where are our priorities? I don't know whether vacancies should be held in legal. I don't know whether vacancies should be held in outreach. I don't know what vacancies. I don't know the answer to that. And I don't even know how many we're supposed to have. in order to maintain the budget. Because I think we're clear on what they'd like to do in the future. But clearly, as we look at the upcoming years, 17 and 18, we're still going to have to maintain vacancies. And so I think that, to me, is something that I think we need to see do. I think I've asked for that before. And so I think I think that needs to be a priority then. Not by department and not by division, but overall, where's that going to be? So I think in order for us to do that, I think that's important for us as we come back and continue to talk about vacancies.
And so how do we know when someone's hired? Within our, staff? Like, how do we know? Maybe Sandra, when we're hiring someone, if we're moving them out of the blanket or hiring someone new, who keeps track of all that?
That's kept tracked by HR.
Okay.
Typically, we receive a 628, which is our request for personnel action from the particular program, to request to move an employee out of the blanket into a funded position. So HR receives the hiring request from the program areas, and that information is conveyed back to the departments.
So maybe, Mr. Runner, you know how we're getting reports from other folks about all sorts of things, contracts or, articles. Maybe we need to get a better sense of when someone's moved out of the blanket, who, where, what position. If someone is hired new, where are they going? Because I have the same concern in the field, is that our field is always asking for more people, yet they don't seem to be getting more people, and then we keep hearing about different people getting hired, at different levels. And how are we supposed to monitor that? And I think that's what Mr. Runner is saying is if we don't have a plan where we all want to stick to the plan, then somehow we all need to be aware of who's getting hired and where they're being put in the agency. And if that's easy for you to, since you're letting them know as well, maybe you let us know as well so that we just can figure out, if there's 10 people being hired in headquarters, then, we can say, well, where are the people in the field? But if there are people being hired in the field, then we can tell our field staff, no, we've been getting people in the field, nobody's been hired at headquarters, because there's always this conspiracy that people are getting hired and nobody really knows the information and only a couple people really have the data, and by that time, there's a lot of discomfort and, angst at our district level offices. And so, so maybe that's one solution is to be able to know when people are getting out of the blanket, where they're going, and if new people are being hired, where they're also going as well. So there's transparency, right? That's all people want to know is what is going on.
Well, and my concern is that not only do we know what's going on, but is it strategic? Are we indeed doing it in the way, or is it just, whoever happens to fly the vacancy first is going to be the one that we fill, as opposed to it being strategic. Somebody saying, you know what, we're not going to fly that one. We're going to keep that one vacant because it's more important for us to have this position over here. And I don't sense we've got that strategy. Maybe we do. Do we?
Well, that strategy is what we're building.
Okay.
And what we'll be coming back to you with in January.
Good. Thanks.
Well, I agree with Mr. Runner. I think there needs to be a comprehensive approach to addressing this concern, and evaluate the work studies, do a work study in all the areas. Vacancy's been around long enough to be able to make that assessment, and it should be innate in the process of determining where the position should be and how many positions should be there on a comprehensive basis. The field is supported by administration. Administration's fully aware of the workload and what needs to be there relative to the field. But I also feel that we need to make a policy decision as an organization as to whether or not we're going to operate in a zero-sum gain environment and say that what we're currently doing is adequate for the state of California, or can we do a better job of educating the taxpayer, which thereby increases the funding to the state of California, or additional audits or preliminary audits or managed audits and things of that nature. What can we do to be more efficient? We currently audit somewhere around less than 1% of the entire universe. There's a presumption that the Board of Equalization actually generates the $62 billion that we administer. Simply not true. our organization generates somewhere around $600 to $700 million. Our activity is more on the compliance side than it is on the audit side. We serve to enhance compliance. Thus, the reason we have the highest compliance rate in the nation when it comes to the taxes that we administers. And so, should there be more auditors out there, studies have indicated that there should be, that the percentage that we actually review should be increased. Not to say that they should all be audits, but maybe first-time reviews like you do in the auditing world, where you review it the first year and you say if there's a problem, you just allow them to correct it without assessing anything. Just go in and correct it, report the proper amount, and we're not going to assess your liability as long as you correct this error. As opposed to a 3-year audit where we wait 3 years, and this is just an example, by the way, we wait 3 years and then we assess a 3-year compound audit with compound interest, which forces the taxpayer, could very well force the taxpayer out of the business. So I think that the question is, can we be more efficient, more effective, not as a field agency, but as a one Board of Equalization, as an organization in general. And I haven't seen that analysis. I haven't received that sort of advice. And I don't know that the Board of Equalization has articulated their views as to what we should be doing as an organization. We've done so in the mission statement, which is very general. And I think the mission statements and our policy serves as some guidance. But now we're getting down into the detail as to how do we reflect our mission and our hiring practice and so forth. But that takes me to, you shared with us that we had 613 vacancies, 354 were in active recruitment or paid absent. Where are the other 259?
The other 259 are neither in active recruitment or leave of absence. So
That's
they
a
have
good
either
answer.
recently become vacant or they have been vacant for, in general, more than 6 months.
And can you break that down as to how many have become recently vacant as opposed to those that have been vacant for more? You're saying of this 259, some have been vacant for more than 6 months? We haven't been carrying vacancies for years?
Some vacancies we've been carrying for years.
And would those vacancies fall into this category of 259?
That's correct.
Okay, so there are vacancies that we've been carrying for years. How many vacancies are they?
Of the vacancies that are not in recruitment, as of November 1st, 91 of those have been vacant for more than 6 months. In general, I've seen vacancies that generally range from 6 months to 2 years.
You still not answering my question. If 91 has been vacant for 6 months, they fall within that category. The 168 remaining, have they been vacant for years, over 6 months?
Out of the 613, 259 of them have been historic vacancies that are not in recruitment or leave of absence.
You're reverting back to the 259. We've
Right.
somewhat gotten beyond that. We started at 259. You said 6 months have been vacant for a 6-month period of time, which is reasonable. Left us 168. Have they been vacant for longer than 6 months?
No. Those positions have been vacant for less than 6 months. And they have obviously become our new vacancies. They're in the
Gotcha.
process of submitting their
So the
hiring
91 that have
package.
been vacant, my apologies, 91 that have been vacant for more than 6 months, how much longer have they been, have they been vacant? 6 months, a year, 6 years?
The amount of time that they've been vacant ranges from 6 months to 2 years.
2 years.
There's one position that has been vacant for 4 years.
4 years.
But that's just one. The longest of the positions other than that has been 2 years.
And we're sort of financed or budgeted based on mid-level funding. Which one of these positions how many of these positions are held vacant in order to address our excess over mid-level funding?
At this point, we don't have that data of how many of them are held open to fund the top step funding for the 71% of employees that we have that are being paid above that mid-step.
Okay. So I think it's important that in the interest of full transparency, I think it's important that you sort of delineate these various different categories, and you provide a description of what those categories entail, and then provide what you believe the solutions, or how do we address those different categories of vacancy. And I think that's where, you know, the general public, Department of Finance, the legislature, and so forth, when we go before them and we say we have 613 vacancies, 354 are in recruitment, 259 are not in recruitment, that says you're not doing anything with the 259. You're just not recruiting, you're not doing anything, you just let them sit there. And I think we ought to be clear that that's not the case. And I'm, for one, I'm actually okay with saying that mid-level funding for this agency is not appropriately funding for the state of California. And because of the funding mechanism, as Mr. Renner indicated, because of the funding mechanism, we're forced to leave X number of positions vacant or terminate employees, which we can't terminate them. These employees have seniorities and so forth, and they're our highest paid employees. And so we ought to tell that story. We ought to say where the 259 is, and the ones that are vacancy for less than 6 months, that's saying to me that it takes 6 months to get them into the recruitment process, which is that what you guys are saying?
That's very close to the case. It takes 3 to 6 months to that we're seeing to fill a vacancy on average in BOE.
That's from advertising, interviews, and selection?
That's right. That's from the time that it becomes vacant to the time that the person starts at BOE.
Is it
3 to 6 months.
Is it? Do you know why?
There's two ends to the spectrum on that. Number one, the various departments sometimes are waiting to issue those hiring packages to our HR department. The other issue is that HR in many cases is going through by hand for a certification process, and it's taking time for the listing to go through the HR process.
Yeah, I think I can speak to that. There's various issues that may be impacting the length of our vacancies. What we've noted is that there's a number of positions that are typically vacant for 3 to 6 months before we even receive a hiring request from a program. So that can add to the vacancy. Once we receive the actual request for personnel action into personnel, it takes us about 42 to 45 days to go through the advertisement. There's, various civil service laws and rules that require that we post certain vacancies and have advertisement periods. We order certs, send out contact letters, work with the program in reviewing their position allocation. It's taking anywhere, again, from 42 to 45 days for that process. Once we complete that process, then the hiring packages are submitted to the program for scheduling of interviews. So then there's another component to the back end. So what we found is from end-to-end process, from the time we receive a completed request for personnel action into our office to the time we actually hire an employee in the program, it's taking anywhere from 10 to 17 weeks, so about 4 months. So if you add in how long has a position actually been vacant prior to the package being submitted to HR, along with the whole hiring process, then you are looking at about a 6-month time frame. So there.
Are we talking about, let me walk through an example, and then you kind of give me some guidance if you could. Let's say, for example, an audit position becomes a vacant, and there's an existing hiring list for auditors that's out there already.
Correct.
Or AGPA or whatever the position might be. The district can't just pick someone off the list or start the hiring process and interview folks off the list and hire someone? Can they, or?
They can't. What starts the process is the 628 process. That's the request for personnel action that's submitted to HR. And that's where they request to fill their vacant position.
Let's say they made the request.
Okay.
Can they hire off the list?
Yes, they can. But within that process, there's various different components. So once we receive the package from the program, we're looking at, the package where it typically takes anywhere from 3 to 5 days, and we're posting that job vacancy. So we're getting that vacancy posted on behalf of the program. So at that time, we're ordering the certification list for the program, sending out contact letters if that's the wish of the program. We have to wait for those return of contact letters, and so that we can capture the entire eligible candidate pool for us to forward to the hiring manager for interviewing. So there's various different processes. We like to refer to our workflow within the hiring workflow process. So we have what's called, a request for personnel action. We have our job posting process. We have our application review process. We have the actual hiring, selection, and interview process that's done in the program. And then we have the final approval process. So we have a flow chart that we have out on EBO. We've been tracking.
But I understand that process, but the process, the example that I'm discussing is you got a list.
Mm-hmm.
The individual has decided to leave the Board of Equalization.
Mm-hmm.
We're notice of the termination,
Mm-hmm.
which tells us we got a position to fill.
Right.
That won't start the process. The fact that we've been notified, you have to wait to in the example that I gave, to the district administrator, fills out some forms.
That's correct.
And what's involved in this package is like.
What's involved in that package?
We want to hire, or?
It's a request to fill a vacancy. It could be a straight refill. They have to submit the request to hire. There may be additional approvals at the department level, with their deputies, if they are monitoring vacancies based on, how many vacancies that they have to keep, vacant. They may determine when they send in their request for personnel action.
And when they send you this 628,
628.
you now authorize them to hire?
Yes.
And what's the next step?
Then we're going to post their vacancy. We're going to order their certification list. We're going to get their vacancy posted on the
And
jobs.
how long does that take?
Again, the end-to-end process for HR is about 42 days for that review process. It's
No,
actually.
you're no longer reviewing.
Well, no,
They've notified.
Within that process is actually ordering of a certification list, sending out contact letters, reaching out to the eligible candidates, and waiting for the return of those applications. So we have some we have some process
42 days.
timelines that's built. Mhm.
Okay. And then they interview?
Then what we do is we get the hiring packet, and we forward that to the hiring supervisor. And at that time, they have a list of eligibles that they can start to begin to schedule their interview process.
And how long does that generally take?
Again, we've done some review on end-to-end, just looking at averages. We're looking at, again, anywhere from 10 to 17 weeks, about a 4-month process. Depending on some of our field and district offices, we have really hard to recruit areas where we can go out and advertise several times and not get a viable candidate pool. So it just really depends on, it could depend on a geographical area or classification. Some can take a little bit longer, whereas some can be hired, positions can be filled very quickly within an 8-week period. So it just really depends on the classification.
It's sort of conflict. I mean, the field offices are telling me, and what I hear from the other members, is that given the vacancy, they can fill the vacancy, and much faster than 6 months, that we can get these vacancies filled. So maybe there's a study of what these positions are and whether or not there are existing lists that are already out there that tells us that we need to do more testing. Currently, for some of these positions, we only test every 2 years. And so the list becomes old, and you're down to number 18 on the list, and that makes it complicated itself. So maybe we need to, accelerate our testing process so that we have a backfill of individuals that are interested in working with the Board of Equalization, and then we can just pluck them off the list. But I mean, I don't want to micromanage your department. I just would suggest that you come back or you guys get together and kind of look at the intricacies of these various different positions and try to figure out how to expedite that. And the positions that you can't fill, just tell us. 91 positions we need the salary savings in order to compensate the employees that are above the mid-range and at this level. And those positions will only be filled as these individuals retire. And then we can fill those positions, and we need to have that discussion with Department of Finance as to whether or not it is smart for a revenue-generating agency to fill all of these positions if, in fact, the estimates is true that for every position we generate X amount of revenue for the state of California. So if you have 259 positions that are vacant, depending on where those positions are, that represents lost revenue to the state of California. Thank you, Madam Chair.
Real quick, a little bit of what I'm hearing here is, again, the fact that during the process, at least what I've just heard described, that once a vacancy opens up, that then there's this process to go ahead and fill the vacancies, and a vacancy is filled then. And then there was a concern that I just heard in regards to the fact that unless there's some kind of restriction by the deputy of that department or area, that it needs to be that the vacancy needs to be maintained. That tells me that somebody's made a decision in regards to where to maintain vacancies. And again, I'm unaware of that. I'm unaware of where it is that we've decided to maintain vacancies. And I'll be very honest, I'm concerned that we're trying to maintain vacancies, for instance, in the field, when I don't think we should be maintaining vacancies in the field. I think we should, and I especially don't think we should be maintaining them if we haven't taken a hard look at the headquarters. And so when I was almost just kidding a little bit when I said, well, then I guess it's whoever gets to go ahead and post their vacancy first will get the one filled. Because it seems to be the lack of a plan. So I think that's, to me, what is important for us to deal with out of this conversation. Because I think it is, see, I think, for instance, coming up into the budget discussions with the legislature coming up in this next, well, just a few months away from now, we're going to have to explain to them why it is that we have vacancies. And we need to do it very clearly. Because otherwise they'll just say, why don't you fill these people? Why don't you fill these? Why don't you take care of these? And if they and eventually they'll just slash them down. When to me it's a very simple issue, and that is our pay is over the midpoint. So we have to maintain vacancies. And I think we need to be that clear for them, and I think we need to continue to work with them and finance in regards to figuring out how do we then get budgeted to the point to where we don't have to maintain vacancies. Because when we maintain vacancies, we basically cannot do all the job and the collection that we're supposed to do. So I would assume for every vacancy we hold right now, that's less revenue that we can collect. And so I think somehow we need to continue to tell that story out there. Meanwhile, I'm still convinced that we need to, we need to be strategic as to where we hold these vacancies right now, because I'm not optimistic that that problem is going to get solved next year. But again, I'm concerned that we have not the plan that, again, I hear from my field folks saying they're trying to maintain positions, they're trying to fill positions, they're trying to deal with these, they're trying to meet their staffing model, and they can't do it. But yet, again, I'm a little biased, it seems like a lot of the positions in headquarters gets filled, and there's no staffing model to determine what the priority of that staff is. So that's why I think it's important.
Okay, so I'd just like to add on to that. Can you send us the existing staffing model? Because the last one I saw, I could not comprehend, nor could, my assistant chief of fields when I asked him, what does this mean for our district office? So I'd like to see what staffing model we're talking about now. And then number two, in this list where it says vacancies in recruitment, what is the breakdown? Vacancies in recruitment, 279,
Yes.
July through November. Do you have a breakdown of like where
Who's holding the vacancy?
As far as which department or division and what positions
Yeah.
those are, I can definitely sort those for you and get those to your respective offices. But that's included in the report that we send out every month to you and to the legislature.
Can we get that one?
Okay, I don't know what spreadsheet or information.
You know, for our monthly report that we send out to the legislature, to finance, and to board members, we have a listing of the positions that are vacant, the position numbers, the what division and location they are at, what the minimum and maximum salary range is, how long they've been vacant, whether they're in recruitment or whether they're on leave of absence. And all that information is put into one spreadsheet. But we can definitely sort that to where we can show you where the locations are for various vacancies and what criteria that you'd like
so,
to see.
like
Definitely
out-of-state
work with your
offices,
offices on
district
that.
offices, headquarters, legal, I don't know, whatever other big, okay. Yeah, I mean, I don't need to know, like, maybe we can categorize it into a couple of different categories. Then we can see where we're actually recruiting, right? I mean, that's part of George being able to see what's happening.
Just kind of clarification, so this spreadsheet that you're talking about, you've been passing that out to the district members?
We've been distributing that to board members and staff, to legislative consultants, to finance, and
Okay,
to
let me
LAO.
clarify. Perhaps I'm not reading all my emails, but whystarwars@sco.ca.gov. Please make sure I get those reports because there seems to be some confusion that they go to the ones in the districts and Controller Yee is a statewide official for this board.
Absolutely, I will make certain of that.
Anything else? No? Okay, so no vote on this, right, Ms. Richmond?
Correct.
Okay, thank you all.
Thank you. Take longer to talk about than we had to vote for.
Well, this is the first time we've had such a big open discussion, which is really nice.
Yeah.
Thank you.
It was, thank you.
Okay, Ms. Richmond, next item, please.
Our next item is P7, Technology Deputy Director's Report. Item P7-1 is the CROS Project Update and Actions.
Afternoon, honorable members.
Isn't CROS going to solve our vacancy problem?
We'll just add that to the list. Good afternoon, I'm Chris Coyote, I'm the CROS Project Director, and joining me today is Ms. Trista Gonzalez, CROS Business Manager. We appreciate the opportunity to provide this month's brief update on the CROS project. So CROS and FAST teams continue to get to know each other and collaborate on planning activities in preparation for the increase in implementation activities that will be coming up in the next year. These activities include finalizing the details of the project schedules to ensure we have resources that are trained and available to work on the project, alignment of project management processes to manage our management and reporting of the progress of the project, establishing facilities for training and testing on the project, and completion of the technical environment setup. We also continue to work with the Department of Finance and the California Department of Technology in clarifying the details of the Special Project Report number 4 and the CROS budget change proposal that you approved in October to be included in the governor's January budget. This collaboration has worked well over the last 2 years and has strengthened the partnership between BOE, the Department of Finance, and the California Department of Technology. As of the end of October, our budget status is for the year-to-date fiscal year 16-17, our actual expenditures are at $2.763 million, which is about 27%, which is on track of what we anticipated. And our project to date is at $37,232,000, which is about 80%, which is also on track of what we expect to be spending at this point in the project. And with that, I'll turn it over to Trista to give you some more information.
Good afternoon, Madam Chair and honorable members. I'm Trista Gonzalez, CROS Project Business Manager. In the program areas, we've been working primarily on 2 efforts: providing staff demonstrations of Fast Enterprise's core product as well as pre-implementation activities. The demonstrations of FAST's core program, GenTax, began in November and will continue through December. These demonstrations are being provided to all impacted staff throughout the agency and contain an overview of the functionality and the capabilities of the GenTax product. Because staff is actually getting to see the product rather than just hearing about it, it's generating a lot of excitement, similar to the phrase, "A picture is worth 1,000 words." Therefore, to keep staff engaged, we are planning to share visuals, which may include screenshots, videos, webcast demonstrations, or any other potential ideas during the implementation and as it progresses, getting closer to final implementation. Also, I'm happy to report that we have started the pre-implementation activities specifically with the contractor FAST. Staff throughout the agency are helping FAST understand our processes and our day-to-day activities. These discussions will assist FAST in configuring the system to meet our current needs as well as our future needs. This concludes this month's report, and we're prepared to respond to any questions.
I do have a question. Unrelated to this, perhaps, but I went out to the Oakland office to watch the cashier processing for a cannabis client. And basically, we have a cash counter that's not connected to any sort of software. And so the cash counter counts it, then the clerk has to manually write it down and then go to the computer and input it again and then write it on a deposit slip again. I mean, there's just 3 areas where numbers could be, transposed. They could be, one number is off. I mean, isn't there a way that they can do the cash counter, attach it to some computerized where it comes up, they can, put the deposit slip, print it out, and therefore it takes away, 3 hands manually writing it all down or inputting in the computer?
Yeah, in regards to CROS, that would be one of the interfaces that we have for CROS, so we can establish that, and when they get to defining the requirements for that interface, they can address that, so it would tie right into CROS to do exactly what you're saying. It would eliminate that manual processing with that technology.
And where is this in the queue in terms of priority? Because we're going to be probably getting a lot more cash in our district offices, so I'm just wondering if this is on your radar or...
We'll be starting to look at the interfaces pretty shortly, right after the first of the year, so I'll double check and make sure where that is and get back to you on where that is in the actual queue for doing that.
I believe that's phase 2.
Okay. Typically, the functionalities will be tied to the tax program. So our district offices are in rollout 2, which is scheduled to come on board in April of 2018.
It's kind of like when you get the ticket, you do your reservation at the kiosk at the airport, and it prints out your ticket and also your bag claim, and everything kind of comes in one, checks you in. I think that's kind of so you get one item that's got the same stuff on all of it, right?
So it's just a concern that it'd be nice if it was moved up. Or
Yeah, we'll get that information to you.
Okay. Any other questions? No?
No.
Okay,
Sounds
thank you
good.
very much.
Thank you.
Okay, informational item, no vote. Ms. Richmond, next item.
Okay, so now we'll go back to the hearings. Item C1, this was just postponed. This was Surrey Investments, so it'll be coming back in February. Item C2, Jessica Chase, this is a waived appearance,
Oh, okay.
and it requires a board vote.
Move to adopt staff recommendation.
Second.
Second.
Okay, Ms. Harkey moves. Staff recommendation. Mr. Horton seconds without objection. Motion carries. Next item.
Our next item is C4A, RM Custom Wood Finishing, Inc., and C4B, Ramon Murgui. This is also a waived appearance.
Move to adopt staff recommendation.
Second.
Okay, Ms. Harkey moves to adopt staff recommendation, seconded by Mr. Runner. Without objection, motion carries. Ms. Richmond?
So that concludes our hearings for today. Our next item is closed session.
Okay.
The members will go into closed session to discuss settlements and personnel matters.
Okay, we are back from closed session.
The board members met in closed session and discussed settlements and personnel matters.
All right, the board is pleased to announce the appointment of Trista Gonzalez to the position of Chief Tax Policy Division. This appointment is effective immediately. Please join me in congratulating Trista to the BOE executive team. Any other items?
That
Ms. Richmond?
concludes our business for today.
Okay, thank you all for attending. This concludes the first day of the meeting of the Board of Equalization. We will take a recess and we'll reconvene tomorrow, November 30th at 9 a.m. Same place. Thank you.
Russell?